Good morning. Welcome to the Senate Judiciary and Public Safety Committee. Today is February 20th, 2026, and we do have a quorum present. This is our first meeting of the year. Welcome back to everyone that's here. In a moment, we're going to take some time for some introductions, but first I have an announcement I've been asked to make on behalf of our security expectations and decorum. I'm just going to read it so I don't get in trouble for missing anything that's required. We appreciate your interest and participation in the legislative process. To ensure everyone can view, hear, and understand today's proceedings, we ask for your cooperation in maintaining decorum and civility throughout this hearing. For the safety, security, and comfort of all attendees, please note the following guidelines. Signs and placards are not permitted in the hearing room. Verbal outbursts, shouting, or disruptive behavior will not be tolerated. Disruptive conduct may lead to the removal of those engaging in the behaviors. Applause or other audible demonstrations are not allowed. For safety reasons, everyone must be seated. No standing, sitting, or pacing in walkways or aisles, and no standing or obstructing at your seat. If you require a reasonable accommodation, please speak with our sergeant staff. They are identifiable by the gold badges on lapels and suit coats and will be present throughout the hearing and are here to ensure everyone's safety. So I know at least one person mentioned to me yesterday that he has a tendency to prefer to stand at the back of a hearing rooms, and as I just indicated, if you wish to do so, that's fine. Just make sure you check with the sergeant staff to make sure that it's they know what's going on and they can make the accommodation as in their judgment is deemed appropriate. I do want to recognize that this is our first hearing since last year, and we are missing a very valuable, now former member of our committee, Senator Bruce Anderson. There were some beautiful comments on the Senate floor yesterday, but I just want to make the recognition today that we're missing our colleague and just take a moment to reflect on that in silence. Thank you, members. Now, this being our first meeting back, I'm going to take a few minutes now just to have everyone introduce themselves, the members and the staff, and we also have a new member to welcome to the committee as well. We've had some changes in the membership. Senator Carlson is no longer on the committee. Senator Howe is no longer on the committee with a replacement now, so our numbers have shifted, but our protocols will remain the same, and our important work, of course, remains the same. So I guess I'll start. I'm Ron Latz, Senate District 46. I'm from St. Louis Park, represent St. Louis Park, Hopkins, and part of Edina here at the legislature. I've served in the Senate for quite a few years. I was in the House before that, and on the City Council in St. Louis Park before that. As those of you who watch us know, because I mention it every now and then, I'm a lawyer in private practice. I do defense work, so I'm in the courts on a regular basis. I'm one of the minority on this committee who are actually lawyers, which is historically odd, but I think remains the same for the moment anyway. So welcome back. I look forward to working with everyone on the committee this year. Why don't we just start my left, we'll go all the way down, and staff, as we come to you, just go ahead and introduce yourselves as well, in order.
Thank you, Chair. Doran Clark. I represent Northeast Minneapolis, Cedar Riverside, Southeast Minneapolis, including the University of Minnesota. I'm one of those non-lawyers, but I've worked with lawyers for about 20 years. So I consider myself sort of a translator.
A whisperer, maybe.
We call that law adjacent.
Yes.
I am Bonnie Westland. I represent Senate District 42, which includes Plymouth, portions of Maple Grove, and the city of Medicine Lake. I am a lawyer in my other life, and I practice family law and also mediation and other alternative dispute resolution services. And I am in the 4th year of my first term.
Senator Sandy Pappas. I represent downtown St. Paul and the Capitol and surrounding communities. And this is my 42nd year in the legislature. And my last.
Good morning, everyone. My name is Claire Umuver-Baton. I represent District 66, which includes parts of St. Paul, Roseville, Falcon Heights, and Lauderdale. I am in the end of my first term here in the legislature and have really enjoyed serving as the vice chair of the Judiciary Committee.
My name is Kira Lehman, and I'm the committee legislative assistant.
Nicole Kaplan, the committee administrator, and since they don't have microphones, Linnea Michelson is the GOP researcher back there, and Jackie Clinton is the DFL researcher back at that table.
Ken Backus, I'm the Senate counsel. I handle the criminal side of the committee.
I'm Priya Primo, and Senate counsel, and I handle the civil law and data practices issues.
Chris Turner, I'm the committee fiscal analyst.
I'm Warren Limmer. I represent Western Hennepin County as well as Maple Grove. Please don't accuse me of being an attorney, but the chair would say I play one on TV.
You're a good impersonator, Senator Limmer.
I'm Senator Michael Holmstrom. I represent Wright and parts of Meeker and Hennepin counties. This is my first year in the Senate.
Senator Michael Kroon, District 32, which is Blaine, Ham Lake, Lexington, and Columbus. In my first term, so entering fourth year on the Judiciary Committee here. Prior to the Senate, I was on the Spring Lake Park School Board, and I am a lawyer. Most of my practice has been in real estate litigation, and I'm happy to announce I'm back in real estate litigation officially, so that's a change from last year.
Mr. Chair, Senator Tory Westrom. I'm from central and western Minnesota, Alexandria, and 6 counties in central and western, reaching all the way out to Ortonville along the South Dakota border. Also an attorney, solo practice. Good to be back.
All right, thank you, and welcome back to everyone who is on the committee and to all those who like to watch this committee. We know the throngs of the public who tune in for every Judiciary Committee hearing. It's a very narrow band of people, small but mighty. Pardon me? Quality over quantity. So I'm going to make a few opening remarks to set the table, and then we will welcome our first testifier. The agenda that we have today obviously addresses issues that have been at the forefront of our communities of concern in Minnesota. I'm hoping that and believe that we should all be able to agree that the government must comply with the Constitution. No matter our policy or our position on immigration policy, the tactics of immigration law enforcement must respect the boundaries set forth in the Bill of Rights that were the conditions set by the states for ratifying the Constitution after the failed Articles of Confederation. This should hold true no matter where we are on the political or ideological spectrum, Republican or Democrat, Libertarian or Classic Liberal, believer in limited government or more expansive government, free marketer or socialist. The strength of our nation depends upon and has been illuminated by the people of our Minnesota communities showing up en masse and coalescing around the common standards, not only of decency and respect for humanity, but of adherence to the rule of law and demanding that our government agents act accordingly. We should also recognize and respect the role of the courts and lawyers in defending the rule of law. Ultimately, our democracy depends upon an intact social compact that respects and abides by the rulings of an independent judiciary that knows when and how to rein in government excess and hold government accountable. It is worth noting that Shakespeare's oft misquoted line, "The first thing we do, let's kill all the lawyers," from Henry VI. It is often cited as a criticism of lawyers. In reality, it was spoken by the character Dick the Butcher to rebel leader Jack Cade, who was plotting to overthrow the government. In actuality, Shakespeare was asserting that lawyers are protectors of the rule of law, and removing them was necessary for tyranny to prevail. Since the metro surge of immigration enforcement, defense and immigration lawyers have rallied through listservs and emails, phone calls, and other forums to share information, resources, and tactics to defend those who are unlawfully detained, arrested, and yes, abducted without just cause, without judicially signed warrants, without administratively signed warrants, without probable cause to believe any crime had been committed, and without even reasonable suspicion of unlawful presence. Where detainees were deprived of their Fourth, Fifth, and Sixth Amendment rights, where states were deprived of their 10th Amendment rights, and peaceful protesters and the press were deprived of their First Amendment rights, lawyers stepped in with lawsuits and petitions and motions through the process that is the hallmark of a free society. I will especially note the use of habeas corpus petitions, which guarantee the rights of detainees to force the government to justify that their detention is based upon lawful reasons. It prevents arbitrary or indefinite detention by allowing judges to order the release of persons held without a fair hearing or valid and sufficient legal cause. This hearing is intended as a first step to vet proposals by which we as a state can strengthen our ability to protect our residents from federal government overreach and to hold accountable those who act under the color of law, but outside of the law. To that end, we will begin with the testimony of Muzaffar Chishti. Mr. Chishti is a senior fellow at the Nonpartisan Migration Policy Institute and is a nationally recognized expert at the intersection of U.S. immigration policy, law, and politics. He is also the director of the Migration Policy Institute's office at New York University School of Law, NYU. Prior to joining MPI, Mr. Chishti served as a lawyer in the U.S. labor movement for a variety of garment and textile workers and other unions, and has authored or co-authored over 100 publications on various aspects of U.S. immigration system, admission, and enforcement policies. He has served as chairman of the board of directors of the National Immigration Forum and the National Immigration Law Center, and as secretary of the U.S. Committee for Refugees and Immigrants, and as a member of the American Bar Association's Coordinating Committee on Immigration. We are honored to have Mr. Chishti here with us. I will note that his bio indicates that he was born in Kashmir, India. He received a Bachelor of Science with honors in physics from St. Stephen's College in Delhi, an LLB from the University of Delhi, an LLM, a Master of Laws from Cornell Law School, and a Master's of International Affairs from Columbia's School of International Affairs. Mr. Chishti, we have you on the screen. Welcome to the committee. Appreciate you joining us remotely from the East Coast, and we're honored to have you here. So, thank you.
Thank you so much for having me, and I'm sorry I can't be there in person, but it's so glad to be here this morning and to witness the great work the committee is doing.
Thank you. Why don't you go ahead and present us with your testimony, and we'll leave some time for members of the committee to ask you questions as well.
Well, I'm glad to be here this morning. As I said, I am a lawyer. I'm a senior fellow at the Migration Policy Institute, which is a nonpartisan think tank. We just look at issues of immigration, admission, and enforcement, not only in the US, but in Europe and in Central and South America. We pay a lot of attention at MPI on the issues of the relationship between federal and state and local laws. We have done extensive field research on how the relationship between federal and state and local law enforcement operates inside our jails, inside both in the sheriff's enforcement and police chief's enforcement, how 287G agreements operate. I think that's sort of the background I bring to your committee today. We have watched with a lot of interest what's been happening in Minnesota in the last month or so, and we are glad to see that a situation that began with an intense confrontation between the federal and the state government has now reached some sense of semblance where we can say that the cooperative arrangement that should be the hallmark of any federal system is beginning to shape in the state. We recognize that there is a supremacy clause of the U.S. Constitution, which says that U.S. federal law preempts all conflicting states and local laws. But there's not always a conflict between state and local laws. Our preemption system doesn't mean that there is no role for states and localities to operate in immigration enforcement or immigration functions. But there is a demarcation. There is clearly limits drawn between what federal government can do and what states and localities can do. And obviously, enforcement of federal law is the exclusive province of the federal government. But on the other hand, securing the public safety of the citizens of a state is the function of the state law. And they sometimes conflict, but they don't have to. So in each of these cases, we have seen that when there is a lot of cooperation between federal and state government operations, it works smoothly. That people who really pose a threat to the national security or the public safety of our country or our state are held accountable and quickly transferred to federal government's enforcement mechanisms. And people who don't are not, so that we all can then feel safe in reporting our crimes and being witnesses to the crimes of states and localities. And that's, I think, the demarcation that was lost for a little while in Minnesota. It seems that we don't know all details, but it seems some of that good cooperative agreement has now been reached. So glad to answer any questions.
Thank you, Professor. Could you elaborate a little bit more on the role of the supremacy clause here and how that might affect? We've got some proposals before us today that we'll be talking about for changes in state law. And I understand there's some flux constitutionally right now within the federal courts about where the supremacy clause applies and where it doesn't.
So the supremacy clause is essentially is a constitutional provision which says that all federal law preempts all conflicting state laws. It's quite clear that the federal law has complete authority to decide who is admitted, who stays in, and who's expelled from the United States. So there can't be a state or a local law which is in conflict with that. Like the state of Minnesota cannot on its own decide how many people or what kind of people should be admitted to the country or to Minnesota. The state of Minnesota cannot dictate as to who and on what terms should someone be expelled from the United States. They have clearly earmarked for federal jurisdiction. Like states cannot on its own make working for an unauthorized person to work a criminal offense. So these cases have gone to the Supreme Court. Last time the case went to the Supreme Court was this famous Arizona case on challenging SB 1070 Arizona law, where the Supreme Court clearly delineated that, look, there are some fundamental principles of an immigration enforcement which cannot be in contradiction to us, which the state law cannot contradict. But on the other hand, there is some space where state laws may operate even on immigration function. For example, the best example of that is that states can have their own laws with respect to licensing of immigrants for a particular occupation in a state. The federal law doesn't preempt that. So where there's space left by federal law for states to have some say, that's a valid space for the states to operate. But where there's a direct conflict, the supremacy clause, the federal law prevails.
Could you also say something about, is there a distinction there between federal law and, say, federal agency policies for how they are going to implement or enforce their laws?
Yeah, as we all know, federal laws are broad, and how they're implemented is then governed by federal regulations, or sometimes by operating instructions, even sometimes by memos, because they actually decide the minute ways in which that particular statutory provision is implemented. But again, those regulations and those operating instructions cannot be in violation of federal law, and more importantly, they cannot be in violation of our U.S. Constitution. So having said the importance of the supremacy clause, nothing is more supreme than the United States Constitution, as you so rightly pointed out in your own introduction today. So at the end of the day, all federal laws, all federal regulations, and all instructions and manuals issued have to pass the constitutional muster. And that's why in most of these cases of immigration enforcement that we have seen in the last year or so, why the Constitution has come to play in a much more oversized way than we have been used to in the past. Like you said, the writ of habeas corpus. Writ of habeas corpus obviously has been present in our system since our founding. But in the immigration context, it was rarely used because immigration lawyers just went to immigration courts to enforce the rights of their clients. But with the given rise of the enforcement in the last 1 year, habeas corpus, which is a constitutionally protected right, has now become the vehicle through which many of those fundamental rights which we otherwise safeguard have now to be enforced and implemented.
Thank you. Do any members of the committee have any questions that you'd like to ask Mr. Chishti? Senator Westland.
Thank you, Mr. Chair, and thank you, Mr. Chishti, for being here today. We appreciate your testimony and sharing your expertise with us. So my understanding of the scope of authority for immigration enforcement is that in order to take someone into custody for a potential violation of our immigration laws, my understanding is that there has to be a judicial warrant to take them into custody. Is that correct?
Yes, it's absolutely correct. Yes, it's absolutely correct. They need a judicial warrant to arrest someone, and if they are entering a home or an office of any dwelling, they need the right to enter that place. They need a warrant to enter that place, because otherwise that would be a violation of the Fourth Amendment.
Senator Westland.
Mr. Chair and Mr. Chishti, so would it stand to reason also then that immigration enforcement agents would have no authority to take into custody someone who is lawfully in this country or someone who is a citizen of this country? Is that fair to say?
Mr. Chishti.
They definitely do not have any authority to arrest any citizen of the United States. If they have a reasonable basis to arrest someone, to pick someone who made their reasonable basis, someone is here unlawfully, and then they may be able to bring that person into custody. But certainly to arrest that person, they would need a judicial warrant to do that.
Senator Westland.
Mr. Chair and Mr. Chishti, if someone has been taken into custody unlawfully and in violation of the Constitution, someone who is here lawfully, someone who is a citizen, what remedies currently exist for that person for their unlawful detainer by the federal government?
Mr. Chishti.
So that's a really good question. I mean, as we, probably many of you who are lawyers here, and some of you are obviously very close to lawyers, know that there was a long-standing precedent in our country, a case called Bivens case in 1972, I think, or early, don't quote me, in the early 70s, where if there was an unlawful infringement on constitutional rights or our civil rights by a federal law enforcement officer, there was cause of action. You could sue the federal government. Post 9/11, Supreme Court revisited that case in a case actually called Ziegler versus Abbasi, which significantly curtailed the ability of citizens to bring actions or lawfully placed persons in the U.S. to bring actions against federal government officials. And I think that's why many states now, and I can assure you there is a trend now in this, states are now making it a state action for citizens of the state to bring actions against unlawful and violations, civil rights violations against federal officials. So that's why these new sets of legislative proposals that are now multiplying in many states are basically a way to circumvent and around the curtailment of the Bivens provisions.
And
Senator Westland.
Mr. Chair and Mr. Chishti, for those states that have enacted such state actions, have any of those been successfully challenged in court by the federal government? Where do they stand now in terms of procedural posture for any potential challenges?
Mr. Chishti.
I think to the best of my knowledge, none of them have so far been challenged. So I suspect they will be, and then we'll see, our courts weigh in on that. But right now, they remain unchallenged.
And
Senator
Mr. Chair and Mr. Chishti, so if it is unlawful to detain or hold someone who is a citizen of this country, someone who is a permanent resident and not suspected of any criminal activity or no reasonable suspicion, for those individuals who are unlawfully detained by federal immigration enforcement agents, would it also be unlawful for those agents to withhold papers of those individuals or their personal property once they are released?
Mr. Chishti.
Exactly, especially if there's a cost associated with that. If the person did not get his documentation that would let them show proof or authorization to work, that's a harm. So any cost associated with the action or the inaction of the federal agents would be a subject for action. And I mean, just point out, there was actually, even in this administration, recently a very big settlement made in Long Island here in New York, where some people, and they were not even citizens, they were immigrants in the country who had been held in a jail long after their time for their sentencing of the state crime had lapsed, because they were holding people thinking that ICE will come and pick them up. ICE didn't come to pick them up, and then they were held there without beyond the period they should be held. And there was a multi-million-dollar suit settled. So many of these things have successfully resulted in settlements, exactly for that kind of civil rights violations.
And
Senator Westland.
Mr. Chair, and I will wrap up soon. Mr. Chair and Mr. Chishti, that raises another issue that I certainly am curious about. So if I understand what you just said, so for our local law enforcement agencies and for our jails and for our Department of Corrections, once an individual in one of our state facilities has served their sentence, our state agencies have no authority to hold them beyond that term, even if there's a detention order from immigration. Is that correct?
Mr. Chishti.
Yeah, it's called a detainer. Yeah, there are two, I think, courts of appeals cases which have held that if you hold the detainers from ICE, in this case, are purely requests, that if you hold a person beyond their normal time for service, you could then be liable for actions which may lead to punitive damages.
Thank you. Thank you, Mr. Chair. I think it's very important as we are having this conversation that we have an honest conversation about what has been happening in the state of Minnesota. And we have been told that there will be a drawdown. I understand that Mr. Holman made additional statements today that the final drawdown is going to happen in the next week. But I do not want anyone to think that because this has fallen off news stories that is receiving less attention, that there is that somehow less of the offensive activity is taking place, because we know our communities continue to be under attack. We know that people continue to be harassed. We know that they continue to show up in our hospitals. We know that they are showing up at our schools, and that they are not arresting the worst of the worst, that they are taking people into custody that they have no legal authority to take into custody. And so here in Minnesota, because we care about our neighbors and we care about our communities and we care about the rule of law and we care about the Constitution, we are making sure that there is going to be some accountability for the actions of a federal agency that has not been following the law, that has not been following the constitutional rights that are afforded to every person found in this country. And so I thank you, Mr. Chair, for having this hearing today. I thank the bill authors for bringing these bills, and I look forward to restoring lawfulness to our communities so that folks feel safe leaving their homes, sending their children to their schools, going to medical appointments, and so forth. Thank you, Mr. Chair.
Any other members of the committee have any questions for Mr. Chishti? Senator Westrom.
Mr. Chair, to the testifier, if somebody comes into our country without the proper approval or paperwork, doesn't that give any officer of the federal government or state, if they're enforcing it, a legal right to detain them and hold them because they have broken the law?
Mr. Chishti.
So the broken the law is obviously, a complicated question. If someone, let just be clarified as to what are the elements of the unlawfulness here. If someone enters the country unlawfully at the border once, that is a crime, but it's a misdemeanor. If someone is deported and then re-enters, what we call re-entry without inspection, that's a felony. Those are criminal offenses. On the other hand, if someone is in the United States, has overstayed a visa, therefore is unlawfully present at that point, that's not a criminal offense, that's a civil offense. If someone is in the United States and unlawfully works, that we works without authorization, that's a civil offense. So there's obviously demarcation between whether there's a civil offense or whether there's a criminal offense. So if a law enforcement officer believes that someone has broken the law, they have to have a basis to determining that. I mean, how would you know that someone walking in the street has broken the law? I mean, you couldn't tell this from the face of the person or the accent of the person. And in this case, let me just sort of build on what I said earlier, that it's constitutionally protected right. If you cannot hold a reasonable suspicion, probable cause, just on the basis of some of the parents. And that there's been some confusion whether the Supreme Court recently has revisited. It hasn't. I mean, Justice Kavanaugh especially has repeatedly made clear that just an appearance or an accent or your clothing will not give you a basis to arrest someone. There has to be a legal basis to arrest someone. That means you may have a final order of removal, the judge has issued. Then that may give you a basis to arrest someone. But short of that, you cannot have you cannot arrest someone just because you have a suspicion that someone is here unlawfully.
Senator Westrom.
Thank you, Mr. Chair, and thank you. It goes to the underlying issue, though, if somebody is here illegally, there is a legal basis to hold them, detain them, or arrest them if once you've affirmed as you answered. Now, just on the face, I suppose nobody could tell other than if they've got pictures. That's what law enforcement does a lot, but they also may have a lot more information, just as we're seeing in the Nancy Guthrie case. Law enforcement has a lot of background information in figuring out who they're trying to find walking down the street or hiding in a residence or on a piece of property. So, but you answered my question. The legal basis would be there, and I'm just kind of adding to the last comments that said there's no legal basis to holding it that Senator Westland brought up, and wanted to just make that clarifying point.
But just to be clear on that, Senator, if
Mr.
all,
Chishti.
you're absolutely right that all the information would be available to an immigration officer, which the rest of them, that's exactly what they present to a judge. That, look, this is the basis of us to believe that this person is here in violation of the law, and that's how you get a judicial warrant.
Senator Kroon.
Thank you, Mr. Chair. To the testifier, I believe you said if state and local officials hold illegal immigrants beyond their normal time that they would otherwise be eligible for a release from prison or a jail based on an ICE detention order, I believe you said they could, and I think your word was could, be running afoul of the law. My question is isn't it possible for a state through an enactment of policy or statute, if the state wants to encourage cooperation so that they could make it easier to hold illegal immigrants and exchange that illegal immigrant to federal officials in a controlled environment rather than releasing them onto the street for future street enforcement? Could a state not do that and make it easier and legal for that exchange to take place in a controlled environment like a jail?
Mr. Chishti.
Yeah, I think that's a fair question. I think that's exactly where the degrees of cooperation between states and localities fall. I mean, this is sort of this classic debate about sanctuary jurisdictions. I've looked at sanctuary jurisdictions for quite some. There is no pure sanctuary jurisdiction in our country. I'm absolutely sure about that. No state or city says we will never hand over any immigrants who are in our jails. It's always about degrees of cooperation. And the degrees here, to me, means what level of criminality are you determining is the threshold for you to hold someone. And each state and locality, I think you're right, makes their own determinations. Like in New York City, for instance, there are about 130 criminal offenses for which the state will, or the city in this case, will actually cooperate with federal law enforcement officials to hand over their person. So it's the number of such crimes or the degrees of criminality which determine the level of cooperation. And you're right, each jurisdiction on its own assessment of public safety determines for what categories of criminals is it important for them to cooperate with federal government and for which not. Classic example would be there's a murderer or a robber. Clearly we're going to hand over. But, making a wrong left turn in downtown Atlanta is a felony. So should we cooperate with the federal government on those kinds of, that's the kind of decision each locality and state makes dependent on its own assessment of public safety requirements.
Senator Kroon.
Thank you, Mr. Chair, and thank you for that response. And I think that's an important point, that it is a determination for state lawmakers on how much we want to cooperate and where we want to cooperate. So it's not simply a fact of we're unable to cooperate and we're unable to hold illegal immigrants in a way where we can do this immigration enforcement in controlled environments. We can make that policy choice if we want to do that. If we want to reduce street level enforcement, we have a role to do where we can make that happen. Maybe not eliminate it, but we can reduce it. And so from my perspective, if we're going to be looking at state level policies, they should be opportunities for us to increase our level of cooperation with the federal government so that we can do a lot of this federal immigration enforcement that we've been seeing on the street. We can do that in controlled environments and reduce the street level enforcement. So And we have a role to play in that, and I look forward to being part of that. Thank you.
So I have a follow-up on that, Mr. Chishti. What is the form or the lawful form of that request to hold someone beyond their ordinary release date in a state or local facility? Is it simple? Can it simply be a request? Hey, we'd like you to hold so-and-so until we can pick them up? Or does there have to be some kind of a warrant or a judicial action or some kind of a signed finding that would authorize that request?
I think it's literally, it's literally called the detainer. It's a request issued by ICE in this case to the local jurisdiction that we believe that the person who is in your jail or under your custody is in violation of the U.S. law, XYZ, and we want you to hold them and we'll come and apprehend and arrest them. That I think, I can't tell you the form number that's called, but it is actually a physical form that is issued to the local jurisdiction.
And does there, Mr. Chishti, does there have to be any kind of a legal basis for that? Or can ICE simply submit the form? Are there any findings that they have to make? And what impact
well, I
would
think,
those?
yeah, so as we know by now, there's this, we had this provision of law introduced during the Bush administration called the Secure Communities, which is what solidified a lot of this, is that anyone now who's taken into custody and gets fingerprinted, those fingerprints are matched against both the criminal database and the immigration database. And that is actually managed by a particular cell within the Department of Homeland Security. If the fingerprints match someone who is the agency has determined is in violation of the law, that then triggers the issuance of a detainer. So it's based on the file and the screening of the file within the agency that triggers the issuance of a detainer. So it's obviously based on something. It can't be based on nothing, but it's based on Department of Homeland Security's own investigation about the immigration history of that person.
And then there's a certain level of discretion, you're saying, on behalf of the local unit of government, or if the state were to make a state policy on that?
Yes, typically, and the detainers are not, again, there's a level of assessment of this. Detainers are not issued even by ICE for everyone. They may not be interested, given their own resources, to issue a detainer. If they decide the person of interest, then the local government decides whether to comply with the detainers or no. And it is generally held view now that detainers are just requests. They're not binding on the local jurisdiction. And whether they're complied with or no, in response to other questions we just got, is determined by the local priorities of that particular jurisdiction. That there are certain classes of crimes for which we'll comply, certain classes of crimes which we will not. And that's sort of the negotiated, constant game going on between the federal and the state governments. And I suspect some of that happened with Mr. Home in northern Minnesota.
Right. Senator Umer-Verbeten.
Thank you, Mr. Chair, and thank you, Mr. Chishti, for being here today. One of my concerns is when federal agents break the law, particularly criminal law. And, you know, we have typically had our local law enforcement work alongside federal partners to conduct investigations into the killing of someone. There's a bill that our chair, Latz, will be hearing later on in this committee sort of regarding that. But can you speak to the authority that the state has to enforce its own laws, criminal laws, and sort of where the role that the federal government plays in investigating, you know, a federal agent, if there are any potential conflicts there, and where the supremacy clause would come into effect?
Mr. Chishti.
Thank you so much for the question. I'm really not an expert on joint investigations of particular crimes. I suspect that it's a classic case where states and local cops do what they are best equipped to do, and federal government brings its both investigative, its data sharing, its other means of investigation to bring to the table, which the state jurisdictions don't have, and they work cooperatively. What the degrees of that cooperation are, I suspect that it depends. My understanding is that soon, initially the case is decided what the lead agency is going to be, determined by where they think is it more a federal offense or more a state offense. Once you determine the lead agency, that lead agency determines the level of cooperation they would get from the other agency. But how that mechanics works, I'm really not an expert.
Mr. Chishti, can you say anything about what authority the state or a local jurisdiction would have to enforce their own criminal laws against a federal agent that may have violated those criminal laws?
I think it really depends on the state law, and I think that's why I think there is the resurgence of interest in the state laws about making federal officials hold them responsible. And I think most of this, let's just be fair about this, has happened because there was a statement issued by Secretary of Homeland Security, somewhat supported by the President's Deputy Chief of Staff, Mr. Miller, telling federal agencies that you have immunity. That sort of gave the signal that you're free to do what you should do in pursuit of a federal mandate. And that's really not true. It's just not true under our system of law and, under the constitutional protections. I think that's why the states have now found it necessary, and there's multiple states on this, which have now decided to make their own statutory provisions to make it abundantly clear that you can sue federal agency. And part of it is to do with these recent statements by federal officials, but also, as I said earlier, about the perception that the right to sue federal employees has initially understood in the Bivens case law has been somewhat compromised. And I think this is a way to give rebirth to the old Bivens cases, and states are using whatever authority they have to do it.
And what about the rights of states to enforce their criminal laws against federal agents?
I think they have perfect right to impose their criminal laws. In fact, there was some speculation that one of the two federal agents who was involved in the shooting of Mr. Petty was dispatched out of the state the very next day and transferred to Texas, which raised speculation among many lawyers that he would perhaps be subject to the criminal actions of the state, and you would now have to go through the difficult process of extradition from state. That, to us, just watching tea leaves, was indication that there was some concern in DHS that person could have been prosecuted under state law.
Senator Westrom.
Mr. Chair, to the professor, earlier you talked about the difference between coming into the country without any paperwork or approval being criminal, and if you're here on a visa and then you overstay it, it's a civil action. What is the difference between the penalties or what agents can do to detain you, to the penalty and deport you? What's the difference between those two, if there is?
Mr. Chishti.
Sure. Thank you. There is distinction. So if you enter the country unlawfully, that means without inspection is the formal term. You're committed a misdemeanor punishable for imprisonment up to 6 months. If you're a repeat violator, you have been deported once and you came again unlawfully without inspection, that's a felony punishable, I think, up to 2 years in prison. So if anyone is apprehended in the country, arrested on those two grounds, then you must be criminally charged and you must serve that sentence. At the end of that sentence, you could be removed from the country. Contrast that to the other example you made, that someone whose presence is unlawful. That means they entered country legally but then overstayed, or came legally but worked without authorization. Both of those are civil offenses. You can't bring a criminal charge against them. The only thing you can do is bring a removal proceeding against them on the basis of having violated a civil immigration law. So that's a civil proceeding. You can't jail that person. You can only have a proceeding started to remove them. That's the basic distinction.
And
Senator Westrom.
And Mr. Chair, during that proceeding of removing them for overstaying their visa, what do you do? Do you let them back out where you may not know where they are? Do you detain them until you have a swift hearing? What do you can you detain them for those days or weeks while the hearing is going on before you would deport them, assuming no other evidence come forward that
exactly. So,
Mr.
thank you. So when I was a real immigration lawyer, the first thing you did when you found someone who's detained, you called a bond agency. That you would show up at the downtown immigration office where your client was being held, and you say, "I'm seeking a bond." And typically, the bond would just be issued by an agent administratively. Okay, $500. If the agency decides not to issue a bond, you will go to an immigration judge for a bond hearing. And that's where you had to have a bond agent willing to post a bond before you showed up at the immigration judge. So typically, in such cases, you got bonded out. And then you showed up for your master calendar hearing for the removal, and then you say, "I'm seeking defense, I have asylum claim." Then you will get a merits hearing. Till then, you will continue to be out on bond. What is significant in this Trump administration is that they decided not to grant any bonds. That will hold everyone. And in many cases, they issued directives that you must mandatorily detain someone. And that's what then led to this huge resurgence in the practice of habeas. Because this administration realized that, yeah, you may have a lot of authority in immigration, but you can't override the Constitution. The Constitution still gives the right of habeas corpus. That's why all lawyers today, instead of rushing up to immigration judges for a bond hearing, believing they will not have a success there, go directly to a federal district court and ask for habeas. And that's what sort of the nature of immigration practice has changed. And that's why, and all the reporting shows that the grant rates of habeas is almost 100%. That federal judges have found no basis to hold someone, but it's now deluging our federal district courts. They're doing habeas petitions all the time when they have more important decisions to take care of. Essentially, I think it's kind of, I think it's end round the bond hearings, but that's the price one has to pay for protecting the Constitution.
Senator Westrom.
Mr. Chair, Professor, so the bond hearings that you talk about, is that just been a practice or procedure and a choice? In the current administration has not used that bond hearing as you indicated, as it's been used in the past? Or where is it rooted in law that you have to use the bond hearing versus temporary holding, if that's how I understood you correctly? Is it just a practice, or is it a constitutional provision that the courts have pointed to that says you have to have a bond to be released before you're deported during your hearing? I'm just trying to figure out, is that kind of your opinion, and it's subject to another president or another department's interpretation or discretion, or where would that be rooted in the Constitution or the authority if the bond is the only way to use it?
Mr.
To
Chishti.
detain a civil action of a person that's overstayed. Sorry.
Mr. Chishti.
Thank you. As immigration proceedings are civil, so that's why there's a debate. Otherwise, right to be released is in the criminal context is different jurisprudence. In the civil context, which is what most of these things are, it's written in the regulation that you have the right to seek a bond. And the bond determinations are basically simple. Is this guy a flight risk or not? So the only decision, in fact, since I'm glad you're asking this question, since immigration proceedings are civil, the only reason to detain someone is to make sure that they show up for a hearing. Because that's an administrative hearing. You just want to make sure he's going to show up or he or she is going to show up. And to ascertain that, they are holding you, but to make sure that you also have a right to say that I'm not going to be a flight risk, I will show up for the hearing. You go before an immigration judge for a bond hearing. And the bond hearing is clearly has been our practice since immigration laws, were written by Congress. And so the only decision that the immigration judge has to make is this guy a flight risk or not. And so the amount of the bond, all this is determined by that. And that's why I think when people are concerned about the look, if you really just want to make sure someone is hearing, there are alternatives to that. That instead, even if you don't won't you just, give them a cell phone? We sort of are able to track people by very non-intrusive devices now. Many judges release people on these ankle bracelets. That's one way to monitor your show. Now they are kind of, big, massive, little instruments on your necks, but they're now much easier, less intrusive methods of tracking someone. We call this alternatives to detention mechanisms. So there are more civilized ways of tracking some people. If you don't want to just bond them out on their own, that they will show up, which can effectuate the same purpose that you wanted this person to show up for a hearing.
Thank you, Mr. Chair. One last question, and then Professor, a little in that same vein, if somebody is here criminally, broke into the country or came in illegally, as we distinguished before, they don't have the same constitutional rights as an American citizen that's been born here and is a U.S. citizen. Do they have any constitutional rights based on the courts? And then is there a distinction between somebody that's overstayed their visa and the constitutional rights they would have versus an American citizen, which my understanding is you wouldn't have the same constitutional rights if you're here illegally?
Mr. Chishti.
Oh, well, that's not true at all. I mean, luckily or unluckily, the Constitution applies to every person in the United States. The Constitution does not say citizen. That's been that's the letter of the constitutional provision. That's been the interpretation of our Supreme Court throughout, and that has not changed. The Alien Enemies Act, which is the first case that went in this administration to the Supreme Court. These are people that government decides are not only aliens, but they're enemies. This Supreme Court was keen to point out in the very first few months of this administration that the Constitution applies to all persons. And that if you want to hold someone, you want to deport them, you have to give them you have to give them due process and judicial review. That the Supreme Court has been keen to point out throughout, and I must say that's been keen to point out even in this administration very robustly. So the Constitution survives, that it applies to all persons. It makes no distinction between classes of people.
Any other questions from members of the committee? Senator Holmstrom.
back on the process of detainers in counties or jails or utilizing them, Keith Ellison, Attorney General Keith Ellison, has stated that these organizations, whether it be the county or local authorities, risk civil liability if they hold people based solely on federal immigration detainers. How is that affected if they choose to enter into a 287G agreement?
Mr. Chishti.
Yeah, I think that's a good question. We firmly believe that the detainer stuff is not affected by 287G. 287G, many of you members know, is basically a provision of the law that exists only since 1996 and was never enforced till 2002. It basically deputizes states and local officers to do some immigration enforcement function. But they're to be trained and they're to be supervised. It's not anyone. So they're a designated official. The principle about detainer does not override the 287G. Just because you have a 287G agreement does not give you the right to hold someone beyond what you would normally hold them under your state laws and guidelines. So I think the answer to that is quite well settled. That if you hold someone beyond what you normally would hold them, you are subject to potential civil litigation. And as I pointed out, very successfully, a bunch of immigrants were able to do that even under this administration in a recent case in Long Island, which led to, I think, multi-million-dollar settlement.
Senator Holmstrom.
Thank you, Chair. To follow up on that, so a lot of these cases in Minnesota hinge on a lack of law in Minnesota as being the reason that they prevail in court. At least that's my understanding. Is that correct, that because state law fails to properly address this, this problem exists?
Mr. Chishti.
Yeah, thank you. I mean, I don't think it's the absence of state law. I mean, states don't have any jurisdiction to either enact or enforce immigration laws. I mean, they're just enacting laws which are relevant to the public safety of the state. I think I'm not in the state. I'm not a state expert. I just follow news. Is that I think the conversation has been, at least the allegation of the federal government has been, that the states or the localities are not fully or more robustly cooperating with the federal government. And to me, parsing that just means that they're not cooperating with us in the arrest or release of any person that we're asking them to release, that they are deciding who to release and who not to. And I think that's where the dispute is. And to just restate what I said earlier, that decision about what classes of criminals you will release to the federal government or not is truly determined by each state and each locality. And that's sort of where the distinction between variations of sanctuary jurisdiction lies. And I think that's sort of what probably the debate is within the state of Minnesota and the DHS today.
I don't see any further questions from members of the committee. Mr. Chishti, thank you so much for your generosity this morning, the time you shared and your expertise you shared with us today. It's been very helpful.
Thank you so much for having me, and thanks for all the great work you folks do.
Thank you. Have a great day.
Thank you.
All right, members, the next stop here is the consideration of a number of bills. We are not going to be taking any formal action at the end of our consideration of each bill. There may be some author's amendments relating to them, but it's the intention of the chair to lay all of them over when we're done with our consideration of each bill, and a determination of what will be the next steps for each bill will be made at a different date. We're going to start now with Senate File 3628. Senator Champion has this file, and there is another bill, chief authored by Senator Fateh as well. I don't have the Senate file number. Senator Champion's. And Senator Fateh has the Senate File 3629. They are identical bills. They intend to co-present. So we welcome both Senator Fateh and Senator Champion to the testifier table. Who's going to start?
I'll start.
Senator Fateh, to your bill.
Thank you, Mr. Chair and members of the committee. I'm honored to partner with my good friend President Champion on this legislation as the co-chief author. And so I want to speak to a little bit about what we have been seeing, and then pass it off to President Champion in regards to the language and things like that. And so we've seen the largest ICE operation in our nation's history right here in Minnesota. We've seen an investment of over $170 billion in immigration enforcement federally. We've seen over 3,000 agents deployed throughout different communities, different neighborhoods throughout the state of Minnesota, especially within the Twin Cities metro area and also greater Minnesota. In the area that I represent in Southside Minneapolis, we've seen ICE agents going throughout the neighborhoods and at many times violating the constitutional rights of our residents. We've seen instances in which people with all citizenship statuses, including United States citizens, folks that were born here, that have been questioned, that have been detained, and we've seen two of our community members that were killed, both Renee Good and Alex Preddy, both of which happened in District 62. We've seen instances in which our businesses have been struggling, our small businesses. We've heard stories of ICE agents going into restaurants, for example, in the south side of Minneapolis, entering, closing the door, locking the doors behind them, and demanding the paperwork of workers, the owners, folks that were frequenting the establishment. We know that's not supposed to be happening. We've heard stories from young people that they've been questioned or detained or picked up on campus. We've seen instances in which, especially picked up randomly in the middle of the night, we've heard stories in which students that were picked up, that their families didn't know where they are, their lawyers were unable to locate them and figure out, the university presidents and the schools were unable to know their whereabouts. And so we've also heard stories of students hearing from them, students especially that were born here in America, saying that they're afraid to walk around without carrying their passports. And in 2026, that shouldn't be happening. We've seen operations going on in schools as well, including instances in which students, staff have been tear gassed, pepper sprayed. That should not be happening, especially to our young people, our students. And so right now, there is no legal path for individuals who have had their constitutional rights violated, in which federal immigration officers can be held accountable for those violations or sued for those violations. We have yet to see an end to the occupation that we've been witnessing, but even when it concludes, we know that that's not enough, that there has to be accountability for the injustices that we have witnessed. And so with that, I want to pass it off to President Champion.
Senator Champion.
Thank you so much, Mr. Chair. Thank you to the committee for listening to this bill this morning. And I am pleased to be joined by Senator Fateh as we seek to provide a remedy for Minnesotans. Mr. Chair, I'll be brief because I know that you have a number of different bills to hear today, but I think it's important to put some context around why this bill is important. Most people have heard about the federal law known as Section 1983 that allows people to sue local and state officials if they violate the Constitution as a means of enforcing already existing civil rights. There is, however, no equivalent federal statutory law that allows people to sue federal officials. As such, federal immigration enforcement officers can't be sued for violations of constitutional rights. Some have also heard about the Bivens Act, whereas in the past allowed for a cause of action to be brought, but although the Supreme Court has not expressly overruled Bivens, it has declined to recognize a Bivens action for nearly 50 years. As a result, people whose constitutional rights were violated by federal officials now, in many instances, are left without a legal remedy. This bill remedies the lack of a federal Section 1983 and the erosion of Bivens action by creating a right of action and giving individuals the right to a cause of action against federal officials. And namely, when you look at Senate File number 3628, which is also identical to Senate File 3629, the first section is the cause of action. What it does is that it establishes a civil cause of action against any person who, under the color of any statute, ordinance, regulation, custom, or usage of the United States or any state, violates another person's rights under the United States Constitution or the Minnesota Constitution. The court may award to a prevailing party damages, including injunctive relief and reasonable attorney fees and costs, and the statute of limitations for action under this section is 6 years. Subdivision 2 prohibits a state or local law enforcement agency from entering into a partnership with a federal agency unless the federal agency agrees in writing that the agency will abide by the United States Constitution and the Minnesota Constitution, and the agency's officers may be held liable for any violations of the federal or state constitution. Mr. Chair, this is to, I don't want to say react to, but provide a tool for Minnesotans, because this is our state where I've been out in the streets there. I've seen the constitutional rights violated of constitutional observers. We've seen people who are just looking to, record what is happening, and the list goes on and on for their rights to be violated. You'll hear from some of those today, but that's the context and why this bill is important, because it gives Minnesotans a tool to take a federal official to court if their constitutional rights have been violated, whether that's the First Amendment, Fourth Amendment, Sixth Amendment, Seventh Amendment, 10th Amendment, you name it. And they still have to prove it. And so, but here's a tool that allows them to do so. So with that being said, Mr. Chair, we do have our first testifier, if it's okay with the court. Excuse me, with you, Mr. Chair, I'm so used to being in court. I said, is it okay with the court, right? Right? It's Megan Forbes. She's with.
You can call me Your Honor if you really insist.
Your Honor, Your Honor.
But I've made the mistake plenty of times like you have, Senator.
Megan Forbes is with the Institute for Justice, and she's here to give some brief context as well.
So what we're going to do here, Senators, is we have 5 people have been identified as testifiers on behalf of this bill. And I think we told you this ahead of time. We're going to have to limit the time of the testimony. So we're asking members to focus on 90 seconds to 2 minutes each for testifiers, so we have time to fit everyone in. So welcome, Ms. Forbes. If you go ahead and identify yourself and your affiliation for the record and present us with your testimony.
Thank you, Mr. Chair and members of the committee. My name is Megan Forbes, and I'm Senior Legislative Counsel at the Institute for Justice. We're a nonprofit public interest law firm that works to protect civil liberties, and we appreciate the opportunity to testify in support of this bill. This bill responds to a serious problem. There are not meaningful legal remedies available for constitutional violations by federal officials in state or federal courts. Right now, if a federal official goes into your house without a warrant, trespasses on your land, takes away a legal firearm, retaliates against you for exercising your right to free speech or freedom of religion, beats you, or even kills you, there's not much you can do to protect your rights. You cannot sue them in most state courts. You cannot sue them in federal courts, and that's wrong. A right without a remedy is not much of a right at all. This bill restores a legal mechanism that was once available at common law and under federal precedent. It's an important fix that brings much-needed reform. 5 states already have state causes of action authorizing suits for damages for violations of the Constitution, and some of these laws have been on the books for decades. This bill creates accountability, which builds trust. Trust is a critical part of law enforcement, and when government agents think that they can act with impunity and appear to do so, it breaks down that trust and makes law enforcement interactions less safe, more confrontational, and less effective. Lastly, I'd like to note that this bill opens the courthouse door, but judge-made immunity doctrines would still make these cases difficult. There's also bipartisan legislation this session that would complement this bill by waiving those immunity defenses to give civil litigants a fair chance to prove their case, and that's another needed reform. So to wrap things up, we encourage the committee to support this bill and to stand with the Constitution and the state's right to enforce it. Thank you.
Thank you, Ms. Forbes. Appreciate your testimony. So what I'm going to do is identify the folks who are going to be next, and then, so if Ryan Eklund, or is Ryan also from the Institute for Justice, as I understand? Okay, are you coming forward? So why don't you come on up and take Ms. Forbes' place at the testifier table? And John, is it Baylor or Bowler? Baylor? Or someone else from the ACLU scheduled to testify will be next. All right, thank you. Go ahead and identify yourself for the record.
Yes, thank you, Mr. Chair and members of the committee. My name is Ryan Eklund. I'm a resident, lifelong resident of Minnesota, current resident of Woodbury, Minnesota. I'll be very brief in terms of my interaction with ICE. On January the 12th, I'd finished taking my 7th grader to school, was stopping by the local grocery store when I saw an ICE vehicle essentially patrolling through the lanes in the parking lot. This was the first circumstance where I saw an ICE vehicle sort of in the flesh in my community after hearing for a number of days that they were present in my community and actively pursuing actions against people that they felt were there illegally. At that point, I felt a strong sense of responsibility as a citizen, as a member of my community, to hold the individuals who are instilling fear and anxiety in our communities accountable for their actions. So while trying to keep myself as safe as possible, stayed in my vehicle and grabbed my cell phone and started recording them from a good safe distance. At approximately 90 seconds to 2 minutes later, they parked in an adjacent parking lot. I parked near them, and one of the ICE agents got out of their vehicle, came up to my window, took a photograph of me, and then immediately got back into their vehicle. At which point I continued to follow them, recording all the while, as they then went up the street approximately a mile away and turned into my neighborhood, onto my street, and into my cul-de-sac. They essentially led me to my home in a clear effort to show me that they know who I am, they know where I live, and that I should not continue to hold them accountable. I continued to do so. Continued to follow them, at which point, after following them for a total of about 8 minutes, I was then boxed in by 2 different ICE vehicles. I was forcibly removed from my vehicle. One of the ICE agents opened the car door. Another one crawled into the back seat and put his arm around my neck, used his other hand to remove my seatbelt, at which point 4 other ICE agents removed me from my vehicle, put me to the ground, put me in handcuffs, and put me to an unmarked white van, and then led me to the Whipple Federal Building. I say all of that to say this. The room that I was in for the 10 hours that I was in the Whipple Federal Building with leg irons on my legs, the room that I was in was then filled throughout the day with a total of 8 U.S. citizens, all of whom were utilizing their constitutionally protected rights to record the activities of ICE agents. At no point in time was I impeding their investigation. At no point in time was I causing alarm or awareness to their presence. I wasn't honking my horn or flashing my lights. I was simply recording them from inside my vehicle. This kind of precedent is a dangerous one. And I would encourage the members of the committee to strongly encourage what this bill does, which is simply provide citizens a mechanism by which they can protect and hold those accountable for violation of their rights. What I did was done under the guise of accountability, and I still believe that holding the individuals accountable for their actions is what I did and what I will continue to do.
Thank you for your testimony today. So you can go ahead and depart the testifier table. We'll invite John, is it Baylor? I want to get it. Beeler. Option 3. Sorry, I also want to remind members of the audience, the decorum here, there is to be no display of expression, support, or opposition to any of the testimony that's here today. If it happens again, any individuals that do that will be removed from this hearing room. We have proper decorum and respect for all views that come before this committee. Mr. Beeler. Next will be Jaylani Hussein.
Thank you, Chair Latz, members of the committee. My name is John Beeler. I'm the Policy Counsel with the ACLU of Minnesota. We're testifying today in support of SF 3628. For the last few months, Minnesotans have watched as their neighbors have been gassed, pepper sprayed, dragged from their cars, detained without cause for hours, sometimes days, along with 2 extrajudicial killings. There's virtually no pathway for private individuals to sue federal officers for violations of the U.S. Constitution. While 42 U.S.C. 1983 provides a federal remedy for constitutional violations by state and local government officials, there is no comparable federal statutory remedy for such violations by federal government officials. State legislatures can and must fix this gap by creating their own laws, sometimes known as Converse 1983 laws, that allow individuals to sue federal officers for violating the U.S. Constitution. The bill does apply uniformly, though, provides remedies under the federal and state constitutions and against federal, state, and local officials. That parity, that equal treatment of government officers provides this bill a necessary constitutional grounding. Currently, people can bring claims against state and local officials for violations of constitutional rights, the 1983 statute, and against federal officers for state tort claims under the Federal Tort Claims Act, but crucially not for violations of their constitutional rights. In 1971, the Supreme Court held that the U.S. Constitution itself created a right to sue federal officers. That's the Bivens case that Senator Champion discussed, but subsequent case law following that decision has whittled away that right, creating a legal accountability gap for federal officers that is especially alarming in light of their current behavior. We support this bill because it fills that crucial gap. Remedies for violations of constitutional rights by federal actors, but also because it provides an independent state-level remedy for violations of constitutional rights by state and local officials, separate from that federal 1983 statute. We urge this committee's support for SF 3628. Thank you.
Thank you, Mr. Beeler. Appreciate your testimony. Mr. Hussein, Senator Champion.
Jaylani Hussein is not here, and it's my understanding Suleiman.
Yeah, Suleiman, who is the deputy director, he's here in replacement of Jaylani, who couldn't make it today.
That's fine. He's welcome to come forward. And then after that will be Christopher Marty.
Thank you, Mr. Chair.
Thank you, Senator. Good morning. If you go ahead and identify your full name for the record and your affiliation.
Good morning, Mr. Chair and members. My name is Suleiman Aden, S-U-L-E-I-M-A-N, last name Aden, A-D-A-N, and I'm the Deputy Executive Director at the Council on American Islamic Relations here in Minnesota, and I'm here in support of Senate File 3628. We here in Minnesota often are the place people come to when they believe their rights have been violated and they don't know what to do next. As leaders that do ongoing knowing rights trainings, we have folks that have come to us and said, you've told us what our rights are. However, when we flex our rights, those don't seem to matter. Every week we sit with Minnesotans trying to understand what protection actually means in practice. In real life, when systems fail, when authority is exercised, and when people are trying to figure out what recourse they even have. You know, the Constitution, as someone who immigrated to this country, I took an oath when I turned 18 to what that flag represents and what the Constitution promises. Those words only matter if people can actually use them. And this bill is about making sure constitutional rights are enforceable here in Minnesota. And you'll hear that legal pathways already exist. And yes, federal court is an option. But from where we sit here at Minnesota, helping real families, that path is often too expensive and too far out of reach, and not within the reality of most Minnesotans. Most folks cannot navigate federal litigation, and this bill gives people a state-level path when their rights under our Constitution are violated. And this is not a duplication or making the system harder. It's about access. And it's not about punishing officers. At Care Minnesota, we've worked with officers when the Muslim community or other faith communities have been attacked. It's about setting clear constitutional guardrails so everyone knows the standard. And we trust that you all will make the right decision, because when trust erodes, public safety erodes. And on behalf of Care Minnesota, we urge your support. Thank you.
Thank you for your testimony, Mr. Adden. Was it Adden?
Adden.
Adden, all right. I'm not doing too well with names here today. Thank you for your testimony. Christopher Marty.
Hi there. Hi there. I'm Chris Marty. I am just a citizen. I'd just like to talk about, in support of the bill. On January 11th, right outside my house, there was some honking, and went to the scene and tried to see what was going on. There was a number of ICE agents there. I showed up with a drum and proceeded to just witness what was going on. They started harassing some of the citizens, backed out of the alley really fast, ran into a neighbor's car, proceeded to pepper ball and pepper spray and a couple old ladies, and then they geared up to go into my neighbor's house, Garrison Gibson in Brooklyn Center, and we asked them for a warrant. They didn't present a judicial warrant at all, and they broke down his door in January without a warrant, pointed guns at his kids, and took him away. He was later released. All charges were dropped. So then on the 14th, I showed up again because I heard of another shooting where, some people were saying that they had attacked a pregnant woman. ICE said that the guy had a gun and there was a shovel. All that turned out to be not true later, and it was just made up by them. But they proceeded to blanket the neighborhood with tear gas and pepper spray and totally deny people their right to peacefully protest. And finally, on the 24th, I went to another hearing of a shooting on Nicollet, not knowing what was going on, and I showed up with a drum and peacefully protested, didn't interfere with anything that happened. And they showed up with an armored vehicle and just caked me in pepper spray, tear gas, flashbangs, completely unreasonable response to people asserting their constitutional rights. And I think that the real problem here is that there is no checks and balances. We're all taught in civics class that this should check that and there should be a balance. So I'm very much in support of some sort of action for civilians to do something when stuff like this happens. Thank you.
Thank you for your testimony, Mr. Marty.
And Mr. Chair.
Senator Champion. Mr. Marty, you can go ahead and return.
We do have one more person, Ed Higgins, but he did submit his testimony. And so if you had 90 seconds, great. If not, his testimony is there, but he is present with us as well.
We have distributed his written testimony. If he wants to take 90 seconds to tell us something in person, that's just fine right now.
Thank you, Mr. Chair. And they all know that it's 90 seconds or less.
That might be hard. I'm from Boston, Massachusetts, but I'll try.
State your name for the record.
My name is Ed Higgins. Chairman and members of the committee, my name is Ed Higgins, and I'm a United States Marine Corps veteran, business owner and marketing director, and constitutional observer living with my wife and 2 fur babies in the great city of Columbia Heights, Minnesota. I come from a long line of system builders and public servants in this country. I understand how government is supposed to function. What I've witnessed since the military occupation by this administration's cause-patriot forces is not a system. It is a lawless shit show built on faulty intelligence,
All right, I'm going to interrupt
vibes,
you right
and
now,
personal
Mr.
vendettas.
Higgins. I'm going to interrupt.
I will censor myself. I apologize.
First of all, there is a decorum rule in this committee hearing, as there is in the Senate generally. Everyone is expected to follow it. Secondly, I'm going to remind you, we do have your written testimony. If you go past 90 seconds or 2 minutes at the longest, I am going to cut you off. No disrespect meant, but you're kind of getting in as an added
Understood.
testifier here today as it is. So we appreciate your being here and sharing what you have to share. But just so you understand what we're.
Yes, so ICE agents attempted to murder me twice. One morning at Liam Ramos's house, they brake checked me, they hit me with their car, backed over me, they broke my phone. That's the reason why I wasn't at his house that morning, or that afternoon when he was kidnapped and his father was kidnapped. They also attempted to murder me on February 5th. They tried to box me in. I maneuvered around them and was driving by, and they turned their cars so that they would scrape my car, and then proceeded to to follow me on a 4-minute chase, which is recorded on 911 call, to the police station where they boxed me in and were trying to break my windows with guns. The only thing that saved my life was Scott Mueller from BCA happened to be parked right next to me for a meeting that wasn't even related to anything. He got out of his car and he de-escalated the whole thing. This is just one small moment that I have seen in Columbia Heights 15 hours a day for almost 6 weeks terrorizing our community. Our constitutional rights have been trampled all over our city, and I've seen many more throughout the state. We need to support this bill because there needs to be some kind of accountability. Without accountability, the law is meaningless. Thank you.
Thank you so much for your testimony here today. Senator Champion, I understand there's an author's amendment, an A1 amendment you'd like to offer?
Yes. There's the A1 author's amendment.
Senator Umover Benton will move adoption of the A1 amendment. Is it in our packets, members? Okay, it's in your packets. Would you like to tell us what the amendment does, please, Senator Champion? Or Senator Fateh?
It just deletes, in fact, this was a technical amendment that was given to us. Maybe council could do a better job than I.
Ms. Primo.
Mr. Chair and members, yes, looking at the A1, this just changes the language so it's in line with how we normally draft. Effective dates for causes of action. Yes.
All right. Do all members have a copy in their packets?
It's at the very end.
Mr. Chairman.
Senator Lemmer.
Thank you, Mr. Chairman. Earlier in the meeting, you had said there would be no votes on particular bills.
I did say there might be some
Is this
author's
just to
amendments.
refine the idea for a later date?
Senator Lemmer, I did mention earlier that there may be some author's amendments to some of the bills as well. There'll be no final action taken on the underlying bill
Thank you.
today. Yes. Senator Kroon, do you have a copy? All right. Are there any questions for Senator Champion on the A1 amendment? Any discussion? Senator Umover Benton moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Any further discussion before we lay Senate File 3628 over?
Sorry.
Senator Holmstrom.
Yeah, I have a question for Senator Fateh. Thank you, Chair.
Go ahead. Okay. What's your question? Go ahead.
The Sheriff's Association has correctly asserted that this bill will likely destroy all federal and state-local partnerships. These partnerships are crucial in prosecuting fraud like Feeding Our Future, and obviously will be necessary in prosecuting the $9 billion in fraud moving forward. So I'll just plainly ask you, was it your intent to make these investigations harder, or was the goal just to undermine fraud investigations explicitly into the future?
Senator Fateh.
Thank you, Mr. Chair, and thank you, Mr. Holmstrom, or Senator, I apologize, for that question. And the answer is no. But what we have seen is that at least 14 federal prosecutors have resigned, including the lead prosecutor for Feeding Our Future. So this operation has not been about fraud. It's been made far worse by jeopardizing the current cases that we've seen, and that's a direct result about the actions from our federal government. And if anyone else wants to jump in, I'll allow them to.
Senator Champion.
And just briefly, again, there was no intent at all in order to undermine any investigation or nothing of the sort. In fact, if you look at the the second division, the subdivision 2, really what we're saying is that if a federal agency or others are going to be here and wants to partner with our local agencies, that they abide by the Constitution, the U.S. Constitution, and the Minnesota Constitution. And that's really what they should be doing anyway. But we just explicitly make certain that that is the information that they would have to abide by in subdivision 2.
Any further discussion or questions from members of the committee? Senator Holmstrom.
Follow up to that, are you saying that it's an unintended consequence that it shuts down all the fraud investigations? Because to this point, the only effective fraud investigations, or at least wholesale, have been from the federal agencies, which require help from local authorities.
Senator Holmstrom, if complying with the Constitution shuts down an investigation, then the investigation ought to be shut down. Any further discussion from members of the committee? Not seeing anything further. Senator Kroon, I'm sorry.
Thank you, Mr. Chair. The question is for the authors. We have in our packets a letter from the Minnesota Sheriff's Association that's where Senator Holmstrom's quote just came from. And I'm just wondering if in drafting or creating this bill, that if you've worked with the Sheriff's Association or any other law enforcement agencies.
Senator Champion.
Thank you, Mr. Chair. Thank you for the questions, Senator Kroon. We are open to working with anyone, but we did not work with them specifically on this particular bill, but we did take their thoughts, or what we would believe their thoughts, into consideration. For an example, there was a concern that they expressed that this is duplicative of Section 1983 and will lead to costly and unnecessary litigation. That's incorrect. Because the federal civil rights statute, Section 1983, only applies to suing state and local officials for federal constitutional violations. There is no mechanism right now for federal officials to be sued under 1983. There was another concern that was expressed by them around Bivens, and saying that the U.S. Supreme Court precedent is a viable remedy for federal abuse cases, so that this state-based cause of action is redundant. As I mentioned earlier, and I'm not certain if you're in the room, but the Bivens decision has been dramatically narrowed over the years, making it almost impossible to hold federal officials accountable for constitutional violations. In fact, I mentioned that it's been 50 years, 50. And no action of the Bivens Act for over 50 years. So we don't believe there is a problem there. There was one additional concern that was stated around that state and local task forces wouldn't be able to function. We believe that they would be able to function, and clearly what we are doing here is not to subvert or deter or create a problem for individuals to enter into agreements. We just want the individuals to agree that they're going to function by the Constitution, the U.S. Constitution, and the Minnesota Constitution.
Senator Fateh.
Yeah, thank you. And I just want to add a little bit to that context as well. And so this is also a piece of legislation that is also, we also see in the STAR Act, which is legislation that was also drafted 2 years ago, and a coalition of 50-plus organizations have been working together on that. And so within the STAR Act, there's multiple different sections, and within those sections, the sheriffs, as well as law enforcement from other jurisdictions, there's been multiple meetings on it as well. And so while there hasn't been specifically for this bill, within the STAR Act, there has been conversations with law enforcement.
Senator Kroon, follow up.
Thank you, Mr. Chair. Well, we're creating a new, under your bill, would be creating a new cause of action that the Sheriff's Association says would destroy longstanding law enforcement partnerships that have taken apart major criminal enterprises and caused the capture of some of the most dangerous criminals in Minnesota. It goes on further to say it will devastate federal and state partnerships designed to vigorously pursue social services fraud. Now, you may disagree with what's in the sheriff's letter, but I think what this highlights is that before we go and embark on any major change, creating a new cause of action, where the Sheriff's Association has strong words like that, I think we need to have all stakeholders at the table, take everything into consideration to make sure that we aren't blowing up all sorts of partnerships that we have with the federal government, because there are many that do many, many good things. And so you have to worry about unintended consequences, if that's what you claim the devastation of the federal and state partnerships designed to vigorously pursue social services fraud is. If you claim that's an unintended consequence, we need to get to the bottom of that. We need to have everybody at the table and make sure that we're doing this in the right way. So from my perspective, this isn't even close to being ready to do the kind of work that we typically do here in the Judiciary Committee to make sure that we have all stakeholders at the table and that we've thoroughly vetted a major piece of legislation like this.
Senator Champion.
Briefly, thank you, Mr. Chair. Thank you, Senator Kroon. Senator Kroon, I just want to be extremely clear, is that it appears to me that we do think it's an important principle for all stakeholders to be at the table. There's nothing that would suggest that those stakeholders should not be at the table. But I didn't hear you say that you think that Minnesotans should have a right of action when their constitutional rights are violated, and that, in fact, what we're attempting to do is give Minnesotans a tool for when their constitutional rights are violated. I believe that you're a constitutional scholar, so I'd love to hear you suggest that agents, the federal government, and individuals should not be held responsible when they violate a person's constitutional rights. So you focused on what the state or what the Sheriff's Association said, and we'll certainly talk to them and see what they say. But, Mr. Chair, we would love to hear Senator Kroon tell us that it is not important for Minnesotans to have their constitutional rights protected.
Mr. Chair.
Senator Limmer.
Mr. Chair.
Senator Kroon, did you have a follow-up? Or you and Senator Limmer can wrestle for who goes.
Thank you,
Senator
Mr. Chair.
Kroon.
Well, since Senator Champion called me out and wants me to say something I'm not quite sure about, good intentions are just good intentions, Senator Champion. We're making law here, okay? So while your intentions may be noble, and of course I take constitutional rights very seriously, okay? But we're making law, and we have to think about unintended consequences. We have to think about the several state, federal, local partnerships that we have in place to make sure that we aren't disrupting what the Sheriff's Association is saying, that we're taking apart major criminal enterprises and that have caused the capture and some of the most dangerous criminals in Minnesota. I would assume you don't want that to happen either. And you're in a conclusory fashion saying, well, I just don't agree with what the sheriffs are saying. All due respect, we need to vet this out so that we can accomplish protection of constitutional rights without making sure that we're not blowing up all of our state, local, and federal partnerships that are doing very good work, including combating fraud here in Minnesota.
Senator Champion.
Thank you, Mr. Chair. And to Senator Kroon, you never answered the question. The question is, do you believe that Minnesotans deserve to have a tool when their constitutional rights have been violated by the federal government? I've been very clear in saying that with the Sheriff's Department, as anyone else, that I do think it's important for us to talk to those stakeholders, engage those stakeholders, listen to those stakeholders, and put forth what we believe to be important as well so that we can talk, because it's about Minnesotans. So we don't have a problem with that. But I did state, Mr. Chair, and this will be my last comment, that I did want to have the constitutional expert, which I believe that Senator Kroon is supposed to also be, talk about the importance of whether he thinks Minnesotans should have a tool when their constitutional rights are violated.
Senator Limmer.
Thank you, Mr. Chair. I've listened to this discussion about the possible unintended consequences of a bill like this. I like the idea of protecting constitutional rights. You and I have had discussions like that quite a bit, Senator Champion, over the years. We seem to have been focused on the fraud issues in Minnesota as it might apply to your bill. But there are other issues involving a federal and state cooperation. Take, for example, our VSET investigations, violent crime enforcement teams. They work commonly with federal authorities, and it would be vitally important for us to consider all the players when we are considering your bill. I would hope, Mr. Chair, that when we have further hearings on this, that our law enforcement community would be invited to the table, and that after their deliberations, reading Senator Champion's bill, that we could have a more complete discussion on the consequences in the event that this bill would pass. We certainly want to recognize constitutional rights, but how the bill works is another thing. And so I would encourage us to get all the players in the room and have a full discussion as we vet this bill. Thank you, Mr. Chair.
Just so the public is aware, when this hearing was scheduled, there was an opportunity for anyone who wished to testify to sign up to testify here today. That window was open for 5 days. Sheriffs apparently decided to submit their testimony in writing in the form of a letter. But when we do have hearings, as Senator Limmer's practice was, and as my practice has been as chair of this committee, the public and stakeholders have an opportunity to participate in the discussion. And certainly before we take any final action on this proposal, we will have another hearing and further opportunity for those discussions. And we always encourage stakeholders who are interested to contact the chief authors of a bill to give their input during the process before we come to hearing as well. Any further discussion from members of the committee? Senator Umufer-Benton.
Thank you, Mr. Chair. I just, was rereading through subdivision 2, which I think is really clear that it's asking federal agents to abide by the United States Constitution, the Minnesota Constitution, and to understand that if they fail to do so, they will be held liable. This is about accountability, right? Take an oath to the Constitution. I think that's very reasonable. And if there's a concern that law enforcement is unable to do their job if they can't abide by the Constitution, I'm not sure how to respond to that. It's a very reasonable ask. Accountability really does only exist when there's a means for it, right? So it's important for us to say abide by the Constitution, but there has to be consequences when you do not. And the Minnesotans whose constitutional rights have been violated, they deserve that accountability, and they deserve to have a means to hold those folks accountable. So thank you for bringing it forward.
I'll just add a note, thank you for that, Senator, that our system of justice provides that accountability goes through a judicial system rather than combat, which was the way they did it in other societies throughout history. So it's actually a peaceful means of resolving conflict rather than a violent means of resolving conflict. So it seems to me we ought to be encouraging disputes to go through the justice process to find accountability and justice rather than roving street battles or other means. So that said, not seeing any further questions, or Senator Westrom. I didn't mean to open the door to a whole nother round of conversation. We do have other bills on the agenda. So
I'll be brief, Mr. Chair, but Senator Champion and the committee, in light of the unprecedented fraud in social services and other areas of state government, we've got the Sheriff's Department telling us this would give them serious and significant concerns in pursuing criminal activity and social service fraud. We need to listen, because we've got a fraud problem around here, and we've got a bill here that would do the opposite of trying to help root out social service fraud, and we can't afford to have another $9 billion or whatever the number is fraudulently taken from us. So I think it's something we do need to hold over. If it even sees the light of day, it might need to take that issue more serious, that the testifiers have submitted testimony from the sheriffs. And so I hope we can do that, because that's an alarming sentence or two that they've pointed out to us, and we need to have them engaged in this discussion, because this fraud is a big problem that we need to get our arms around, and that, I think, is the mission of this legislative session, if nothing else.
I'm going to assume that all of us in this room support the Constitution, and our investigators complying with the Constitution as they are investigating any crime, including fraud. Yes. And I would hope my colleagues on the GOP side of this committee will wholeheartedly agree with me that our investigators, with the sheriffs or federal agencies or anyone else, should and must comply with the Constitution when they are investigating. And I personally have no problem holding them accountable if they fail to do so. And they are held accountable in courts of law now, when those who are subject to the investigation and subsequently charged can have hearings to make sure that evidence was lawfully obtained. So we're going to lay Senate File 3628 on the table.
Chair?
Okay.
Senator Fateh, Chief Author, final word.
Thank you so much, Mr. Chair. And I want to make something clear, because my colleagues brought up the issue around unintended consequences, which I'm really happy to have those conversations with them. But we do know what the consequences are of not having this in place, of not having a system of accountability. Take the murder of Renee Good, for example. What we saw after that was the federal government demanding to investigate her widow rather than the shooter. And what we saw with that was that we saw 7 prosecutors resign as a direct result of that, prosecutors that were investigating fraud. So we know that a lack of accountability has actually been jeopardizing the investigations around fraud. And so I want to make that very clear, that it wasn't a direct result of this, it's because a lack of this.
And my final word, Mr.
Senator
Chair,
Champion, final word.
Simply that subdivision 2, it just says that anyone who is going to enter into any agreement abides by the Constitution, both the Minnesota and the U.S. Constitution. It will not and should not undermine any investigations, whether that's fraud, whether that's harassment, no matter what it is. We're only asking individuals to do what they should do anyway, which is to abide by our Constitution. So I'm not sure where all the other conversation is coming from or why, but we'll be happy to continue to have that dialogue, because we want to encourage all of us to abide by our Constitution.
Senate File 3628 is laid on the table. Members, we're now going to go to Senate File 3688. Senator Murphy is here as the chief author of this bill. Senator Murphy, come on forward.
The chair is nice and warm.
Senator Murphy, welcome to the Senate Judiciary Committee.
Thank you, Mr. Chair.
Members, you have Senate File 3688 in your packet. There is an A2 Authors Amendment. Would you like us to move adoption of that Authors Amendment?
Yes, Mr. Chair, I would appreciate putting the bill in the right shape, and I will speak to it when I testify.
All right. Senator Westland moves adoption of the A2 Authors Amendment that is included in the member's packet. Any discussion? All those in favor say aye. 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 Opposed? Motion prevails. The amendment is adopted. Senator Murphy, to your bill.
Thank you, Mr. Chair and members. It is good to see each of you today as we take up Senate File 3688, which creates a civil action for failure to render aid. Mr. Chair and members, I can't say enough how much I wish I weren't here today, asking your support for this legislation I would never have imagined necessary. In Minnesota, we help each other We push each other out of snowbanks. We bring hot dish in time of loss and celebration. We share resources with communities struck by danger and disaster, and we render aid. Since 1991, our law sets rendering aid as a requirement if a person shoots another or witnesses a shooting. On January 7th, Renee Macklin Good was shot and killed by federal agents. On January 24th, Alex Preddy was shot and killed by federal agents. Neither Ms. Good nor Mr. Preddy were the subject of ICE actions, both American citizens. To date, the FBI has denied Minnesota's Bureau of Criminal Apprehension participation in investigations or access to evidence. Because of Minnesotans' presence and video documentation, we have seen horrific shootings of Ms. Good and Mr. Preddy. We heard the foul exclamation of the agent who shot Ms. Good. We saw the video of the agent clapping his hands after the shooting of Mr. Preddy. I won't make us watch those videos again. But in your packets are the NPR APM investigative reporting chronicling the timeline from the moment Ms. Good was shot until she was transported to HCMC. Also included is an affidavit from a physician who witnessed and eventually provided care to Mr. Preddy. After Renee Good was shot, ICE agents refused to render aid to save her life. They denied the pleas of a doctor who was present who begged to give Renee CPR and stop the bleeding. After 6 minutes and 21 seconds, a firefighter reached Ms. Good and has reported that she wasn't breathing, but she had a pulse. Firefighters moved her to render aid. An ambulance and trained staff met them and initiated CPR, and by then she had no longer had a pulse. Mr. Preddy was shot again. She was shot on January 24th. Again, a physician witnessed what happened and begged for access to Mr. Preddy because the agents who shot Mr. Preddy weren't trying to save him. They hadn't even checked his pulse, and according to the physician witness, the agents were counting his bullet wounds. I don't want to live in a place where authorities think their responsibilities include shooting people, but don't include helping the wounded or dying, even and especially if they're the ones who caused it. In Minnesota, we help each other. We shovel our neighbors' sidewalks, we fill sandbags when rivers flood, and we render aid if we shoot someone or witness a person being shot. The federal agents failed this test. They failed their purported training they received, as stated by Tricia McLaughlin, Assistant Secretary of Department of Homeland Security. The FBI is blocking for now meaningful investigation into the pursuit of justice for the killings of Ms. Good and Mr. Preddy. Therefore, this legislation creates a civil cause of action when a person fails to render aid, adding to the criminal penalties already in law. And with that, I can explain the amendment, and we can proceed with questions.
Please go ahead.
Thank you, Mr. Chair. The amendment that you added to the bill moves the effective date to immediately after enactment, allowing lawsuits to be brought for cases occurring on or after December 1st, 2025. This allows for the cases in the Good and Preddy shootings to be filed immediately. The amendment will also apply the affirmative defense provided for criminal cases under this statute to the newly created civil action. I'm grateful that you're taking this up, Mr. Chair. As I said, I wish I wouldn't have to be here with this bill, but the Good and Preddy families deserve justice. Minnesotans expect us to act, and I'm grateful to bring this before you all for consideration. Thank you.
Thank you, Senator Murphy. I don't have any indication that there are testifiers scheduled. Members, you do have in your packet, there's an NPR article in there, and I believe there's a court filing in your packets as well. Is there any discussion or are there any questions from members of the committee? Senator Clark.
Thank you, Chair. Thank you, Madam Leader. I think we all saw the videos where people were held back from providing aid, and it was jarring, it was shocking, it was all the words. And I appreciate the efforts to just make it clearer. And so it's a simple bill, it's a straightforward bill that says you have to help. And that is Minnesotan. That is nothing, you know, that is what we do, and we've seen it over and over in all parts of the state. So thank you for bringing this bill forward.
Any other discussion? Senator Holmstrom.
Thank you, Chair. Senator Murphy, the Minnesota already has a duty to assist statute in section 604A.01 and immunity protections in that statute for people who render aid. How would this new fee shifting causation or cause of action interact with those provisions?
Senator Murphy.
Thank you, Mr. Chair, and welcome to the Senate. I am referring to 609.662, victim duty to render aid, which right now has criminal penalties. We're adding a civil cause of action, especially in the case of Mr. Preddy and Ms. Good, and for any person who would fail to render aid. In addition to criminal penalties, a civil course of action. In this case, and in this moment, as the FBI continues to deny participation in the investigation, this creates the means for justice for the Preddy and Good families.
Senator Holmstrom.
To follow up on that, so if it's creating a requirement to render aid, and this is extending to witnesses by your amendment, that subdivision doesn't just require the need to provide aid, it also requires an immediate investigation to the extent of the person's injuries. So if I were witnessing a shooting, self-defense shooting or law enforcement shooting, whatever it might be, and I call and call 911 and fail to do a proper investigation, doesn't that open me up to liability from the injured individual later if I gave false information unknowingly?
Senator Murphy.
Thank you, Mr. Chair, and Senator Holmstrom. The current law does talk about the reasonableness standard. There's an expectation that you call for help, you call for medical aid, and you conduct CPR. So there is a reasonableness standard that is embedded in the current law that protects people from such a situation. There's also an affirmative defense in the current law.
Senator Holmstrom.
Doesn't the affirmative defense require that somebody is already brought up in a lawsuit or charged with a crime? I mean, somebody's life could be seriously altered because they were walking in the wrong spot at the wrong time, witnessed something, and had to be brought up in a lawsuit. Even though they feared for their lives, they could have tens of thousands of dollars in costs simply because they witnessed something and was later sued by somebody who was just litigation interested.
Senator Murphy.
Mr. Chair and Senator, since 1991, this has been the law in the state of Minnesota that we expect if you shoot someone or you witness someone being shot, that you render aid with a standard of reasonableness involved. That has been our law since 91. That's the expectation for the people of Minnesota. And yes, in this case, we're adding a civil cause of action, but with that same standard of reasonableness and presumption of, the affirmative defense.
To clarify, this has been the law since 91. Criminally, we're expanding this into a whole new world. And I guess the issue is we don't have sue-happy prosecutors, but we certainly have a tort crisis in this country where people are bringing far too many lawsuits, and this opens up to a lot more, in my opinion. But to that point, has any analysis been done on how often this could be added as a claim in civil shooting cases, self-defense or law enforcement related?
Yes, thank you, Mr. Chair and Senator. The number of convictions under 609.662 since 2021 include 5. This is a rarely used law because we follow the law.
Senator Limmer.
Thank you, Mr. President, or Mr. Chairman. Wow.
I hate to think what I'm called behind my back.
There's a Freudian thing somewhere there.
Yeah, there we go.
Maybe a good one.
Senator Murphy, as I looked over your bill, I came up with the same questions that Senator Holmstrom brought up. And this is not the time to dig into the reasonableness standard. Let me give you a situation. Let's say there's a shooting in a crowded bar, and someone returns fire on the shooter, and all of the patrons in the bar scatter and they run away. They're not coming back when there's gunfire in the bar. But the video camera has recorded everyone's presence there. Does that mean that every single person there is liable for running away for the fear of their life? And does that fit into your reasonableness standard or the standard that's created in law? I'm unfamiliar in depth about how that is applied, but nevertheless, it seems like everyone would be, to a degree, liable for running away from a dangerous situation.
Senator Murphy.
Mr. Chair and Senator Limmer, wouldn't the same apply to the criminal cause of action currently in law?
I don't know.
Senator Limmer.
Mr. Chair,
Senator Limmer.
when we have the extended hearing in the future, I'll try and dig up a little more information. We can have hopefully a more involved discussion about this.
Thank you,
Thank
Mr.
you.
Chair and Senator Limmer. We can certainly talk about it between then and now as well.
All right.
Senator Westrom. Any further discussion or questions on Senate File 3688? I'm not seeing any. Thank you, Senator Murphy. Senate File 3688 is laid over.
Thank you, Mr. Chair and members.
All right, I see Senator Port is, here, on the way back. Okay, we're going to go to Senate File 3590, Senator Port. Senator Port, welcome back to the Senate Judiciary Committee.
Thank you, Mr. Chair.
I think what we'll do, you've got an author's amendment
I do.
here for us to adopt as well.
It's the A1.
So, Senator Pappas, would you offer the author's amendment?
So moved, Mr. Chair.
Senator Pappas moves the A1 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Port, would you please describe your bill, including the contents of the author's amendment?
Thank you, Mr. Chair. Chair Latz and members of this committee, thank you for the opportunity to present Senate File 3509, a bill modifying circumstances around when a person may conceal their identity. For months during Operation Metro Surge, Minnesotans have watched federal agents move through our community in masks without visible badges or identifying information. Community members, legal observers, even state employees have reported being shot in the face at point-blank range with chemical irritants, assaulted, and threatened by people that they could not identify and who refuse to give their names or agencies. When that happens, there is no way to file a complaint or seek justice, and there's no accountability when power is abused. We should not need to have a bill like this in Minnesota, but we are at a point where it is up to state lawmakers to uphold the basic principles of our democracy and the rule of law. This bill updates Minnesota's concealing identity statute so that it clearly applies in today's context, including to federal agents operating in our communities. It keeps the basic rule that people generally cannot conceal their identity in public with a mask, robe, or disguise, while preserving common sense exceptions for religious coverings, amusement and entertainment, protection from the weather, protection from smoke, gas, or other airborne toxins, and medical treatment. And it explicitly addresses law enforcement by spelling out when they can lawfully conceal their identity while on duty. These exceptions include when an officer is working undercover and concealment is necessary to protect an investigation or the officer's safety, or when a member of a tactical response team is performing duties where a face mask will substantially reduce a known risk of serious permanent disfiguration to the officer's face. And in the A1 amendment, it describes or defines what an undercover officer is versus a plainclothes officer, this gives an exception for undercover officers. It is unacceptable and unlawful for masked federal agents to harass, assault, and abduct people with no way of identifying who these individuals are. Minnesotans have a right to know who is stopping them, who is using force in our neighborhoods and streets, and who is making decisions that can change or end a person's life. Accountability starts with meetings with something very basic: a name, a badge, a visible ID number. Having transparent, identifiable federal agents is safe for the public and builds public trust. This bill balances officer safety and investigative needs and ensures masked federal agents can no longer act against Minnesotans anonymously and with impunity. I urge the committee to vote yes, and I also have John Buller here from the ACLU.
Mr. Beeler, go ahead and identify yourself for the record and provide us with your testimony, please.
Thank you. Chair Latz, members of the committee, my name is John Beeler. I'm the Policy Counsel with the ACLU of Minnesota. We're testifying today in support of SF 3590. As a society, we entrust law enforcement with significant authority. We allow them to exercise the power of the state in their use of physical force and considerable discretion when they do so. In return, there must be transparency and accountability. When government agents act in the name of the people should know who they are. Transparency in law enforcement makes everyone safer. When the police explain their actions, treat people with dignity, and act with transparency, people are more likely to view them as legitimate and to voluntarily comply. Treating people respectfully decreases the likelihood of a violent encounter. Unmasked law enforcement has been the norm in this country for as long as we've had law enforcement. Across various levels of government, across states, unmasked law enforcement is the standard. State troopers don't wear masks, neither do FBI agents. U.S. Marshals don't wear masks, sheriffs don't wear masks, judges, prosecutors, defense attorneys don't wear masks, politicians don't wear masks. The idea that DHS, ICE, and CBP need masks to protect their identities to keep them safe is not based in reality. A review of DHS and ICE press releases since January 2025 indicates that the theoretical scenario they have discussed has never actually occurred. At no point in time has an officer been seen conducting his work, identified, and subsequently attacked while off duty. This policy is supported by our state and local law enforcement who routinely go unmasked. And it's also supported by parts of the federal government. The FBI issued a bulletin last year urging federal agencies to ensure federal officers clearly identify themselves. The FBI pushed this policy to avoid the obvious outcome. If law enforcement is masked, unidentifiable, and heavily armed, and resisting arrest is a crime, then criminals will take advantage of that public trust and that public fear. They will wear masks, they will hide their identities, and they will carry weapons, and they will threaten potential victims with the perceived power of the state. This is not theoretical. The FBI cited at least 5 incidents, including burglary, kidnapping, and attempted rape, committed by people impersonating armed, masked federal agents. If these crimes continue, they will put us all in danger, including our law enforcement officers, who people will no longer trust. Finally, this bill is compliant with federal law. California passed a similar bill with one crucial difference. It did not regulate state and local police. State laws are only invalid under the Intergovernmental Immunity Doctrine when the state law regulates the United States directly or discriminates against the federal government. This bill applies uniformly, not only to local, state, and federal law enforcement, but to all people within the state of Minnesota. We urge the committee's support for SF 3590. Thank you.
Thank you, Mr. Beeler. We have 2 other people signed up to testify on this. We'll start with Kat Solonik-Schlatt. And Also, if we can have Shireen Bhatia come forward and take the other testifier seat as well. Mr. Beeler, do you plan to stay there? Okay, then Ms. Bhatia, why don't you wait to come forward, and we'll hear from Kat Solonik-Schlatt first. Go ahead and identify yourself for the record and give us your testimony, please.
All right. Chair Latz and members of the committee, thank you for the opportunity to share my testimony. My name is Kat Solonik-Schlatt, and I am a Minnesota mom of 3 great kids and wife to the love of my life. On the morning of January 7, 2026, my wife was at Powderhorn Park in Minneapolis with our children, while ICE agent Jonathan Ross shot and killed Renee Good just a few blocks away. My wife brought our children to Powderhorn Park that morning to go ice skating. They were wrapping up, taking off their skates near the minivan when my wife heard a commotion across the parking lot. She saw ICE vehicles staged there and saw people who appeared to be just teenagers, 3 of them in the back seat of an ICE vehicle with the windows down. As a civil rights attorney, she made a deliberate choice, not to obstruct or impede, but simply to observe and try to get the names of those being detained so she could notify the families of the detainees. She identified herself to ICE as an attorney and maintained what absolutely should have been a safe distance of several yards from them. What happened next was unconscionable. Without any verbal warning, a masked federal agent sprinted toward the love of my life with a chemical weapon drawn and pointed at her face. He fired 2 rounds of chemical bullets twice at point-blank range, approximately 1 foot from her face. The force was so great it whipped her head back and buckled her body, all in front of our 7- and 8-year-old. She was immediately overcome with extreme pain, choking, vomiting, unable to see or breathe. In freezing January temperatures, she was forced to strip down in a public park to escape the burning chemicals covering her body. She was helped by a nurse who responded to the scene and was taken to the park's rec center to be rinsed off immediately. She was not able to work that day or for days after and was soon diagnosed with a concussion and whiplash. Weeks later, she still struggles to look at the screens and was referred to a concussion center. She has experienced panic attacks and persistent fear when encountering ICE around our neighborhood again. Our children are traumatized. You may notice that my wife and I share a common identity with the Good family, besides experiencing assault by masked ICE agents on the morning of January 7th, being gay moms. Our neighborhood draws families like ours and immigrant families alike because we believe it will be a safe place to raise our family and pursue building productive lives in our community. That has all been turned upside down by masked vigilantes who have wrought terror in our neighborhood. Here is what is critical for this committee to understand. We cannot identify the agent who assaulted my wife. ICE and other federal agents with DHS have been concealing their identities, wearing masks, refusing to identify themselves, and operating without badges or visible credentials. When agents hide who they are, there is no accountability. Victims cannot file complaints, attorneys cannot pursue justice, our constitutional rights cannot be upheld. No one in Minnesota should be assaulted by federal agents, and no one, whether they are part of the federal government or not, should be allowed to hide their identities while they act violently with impunity. Minnesotans need justice and leadership from this state. This starts by telling the truth about what's happened and passing bills like SF 3509. Thank you.
Thank you for your testimony. Ms. Bhatia, come on forward.
Good afternoon, Chair Latz and members of the committee. Thank you for the opportunity to testify today in support of SF 3590. My name is Shireen Korbatia, and I'm a proud Minnesotan of 4 years now. I'm a practicing attorney in this state, specializing in intellectual property matters, and I engage in pro bono work as well with the Volunteer Lawyers Network in their housing eviction expungement matters. I moved here for my career in 2022. I fell in love with this community and even met my fiance, Aaron, shortly after moving here, a native Minnesotan. We now have our first home together in the greater St. Paul area, and we love it here. That's why I'm speaking up today to support this bill to restrict federal agents, especially ICE, from terrorizing Minnesotans through wearing masks indiscriminately and seemingly to conceal their identities. Although Operation Metro Surge is allegedly ending, we have yet to see meaningful de-escalation. Almost every day for the last week, ICE has been spotted and masked in my neighborhood or even near my workplace. Many of the local businesses that I know in my neighborhood are owned by immigrants. Their doors are closed out of fear of their safety, regardless of their status. Even as a US citizen myself, I have had people asking me to exercise caution. Be careful, they say. Be safe, because I cannot hide how I look. I am an Indian woman and a US citizen, a tax-paying resident of this state and this country, and I am a proud daughter of immigrants who sacrificed everything to be here. They worked hard, and they created a life for my family. We are the American dream. But that dream is under attack. In an attempt to protect myself, I have been carrying my passport, along with my license, every single day since last January, because of the way ICE has been treating people who look like me, even citizens. I know this because I've seen them. My heart races every time. Our local law enforcement are required to wear badges, show their face, identify themselves, all pursuant to the laws of this state and this country. So why is it that ICE agents, federal agents, who do not show their face, perpetually refuse to follow any kind of due process, are somehow allowed to evade what most law enforcement are required to do? The answer is there is no good reason. This was never about enforcing the law. This was about terrorizing a city, starting with masked agents roaming our streets to kidnap anyone who fits their so-called description, all while hiding behind a mask. This bill today addresses that. This bill would create carved-out exceptions about when federal agents may be masked, and otherwise would require them to be unmasked when interacting with Minnesotans. If not, they face a misdemeanor. It gives us a path towards the first steps of accountability. It is no secret that the past several weeks have been a torment for this state. We've lost innocent people, including Renee Nicole Good and Alex Preddy. We've seen families ripped apart and torn away from their homes and all. It's time to move forward. It's time to heal. It's time to change. I ask that you enact, change, and vote for this bill. Thank you.
Thank you, Ms. Batia, for your testimony. We don't have any other testifiers scheduled or signed up for this bill, so we'll open it up for member questions and discussion. Senator Clark.
Thank you, Chair Latz. Thank you, Senator Port. To be clear, this puts all law enforcement officers acting in Minnesota on the same playing field. Is that correct? Did I hear you?
Senator Port.
Thank you, Senator Clark, Chair Latz. It puts everyone with a job, every person in Minnesota, on equal footing. It does spell out specific exceptions for law enforcement, and those apply to federal officers as well as state officers, yes. But this, the reason we built on this statute that already exists in Minnesota is because this is already Minnesota law. Like, this is not a new law. So we are spelling out when the exceptions for law enforcement are. But otherwise, this law, everyone in Minnesota would need to follow this.
Thank you.
Senator Clark.
Thank you, Chair Latz. Thank you, Senator Port. And I think there's an urgency in this as well. You know, I think and there's a pride in work in this. So share your face, be proud of what you do. You know, I represent Central Avenue in Northeast Minneapolis, and we've had many incidents where people have been sprayed in the face, similar to our testifiers, with mace and pepper spray and other things. And in reviewing the videos, whether it's surveillance or an observer's camera, it's going to be very difficult to figure out who this is. So this feels like a good, easy step to be able to hold people to account when they have gone too far in performing the actions of their job. So thank you.
Any further discussion or questions? Senator Holmstrom, and then Senator Westrom.
Chair Latz, I'd like to offer the A4 amendment.
All right, staff will distribute the A4 amendment. Does the staff have an A4 amendment? Oh, here we go. Okay. Thank you. So Senator Holmstrom has presented for our consideration the A4 amendment. Senator Holmstrom, just out of curiosity here, did you share this amendment with the chief author of the bill before presenting it here to the committee today?
I did not. It was completed this morning.
I'm sorry?
It was just completed this morning.
Did you notify Senator Port that you had an amendment
I did not.
that you were working on that hadn't been drafted until this morning?
I have not. It's not required.
It's not required, but we've had this conversation in this committee over the years about the appropriateness of attempting to share amendments with chief authors if possible, so that they have a heads up that they might have an issue to deal with in committee.
I'll happily take that under
maybe
advisement. Thank
Senator Holmstrom, I know that you're new to the legislature, but there are certain decorum and protocols that we are going to follow in the operation of the committee. One of those is we try not to talk over each other. Okay. Second of all, we try not to speak until we're recognized. Third is conversations go through the chair. So rather than jumping in and following up a question to a testifier, first you wait to be recognized for a follow-up, and then you speak through the chair to the testifier. These are just standard protocols, and I know you'll get used to it. Senator Limmer was very meticulous in enforcing the same protocols when he chaired the committee. So we try to do it just so the record is clear for the public when they hold us accountable. They know who it is that's speaking, and we can also manage the discussion more easily that way. It is also not required, you're correct, to share amendments with anyone ahead of time, but it is encouraged. So for future reference, so that we can respond meaningfully on the merits to the amendments, I'll encourage you to do so in the future. I also have a question. Do you have you sought any input from fiscal staff about what fiscal impact this amendment might have? Senator Holmstrom.
We have not.
We have not?
My apologies. I have not, sir.
Okay. So I'm just reading through the amendment here. It appears to increase criminal penalties for doxing law enforcement officers, and then creates new crimes for doxing or disseminating personal information about any person in the state of Minnesota. Am I understanding that correctly, Senator Holmstrom?
Thank you, Chair. Yes, that's correct.
Mr. Chair, point of order.
Senator Westrom.
Mr. Chair, traditionally, the custom of committee is also to let a member introduce their amendment before the chair starts grilling them on what the amendment means. So maybe we could step back a little and have it introduced to the committee so the rest of us can hear the presentation of the author, and then maybe your questions are more appropriate once we have discussion and have it presented. But that's normally what the process has been. So I'm a little puzzled the actions you're taking right now. So I just raise a point of order that that's not the normal way we introduce amendments.
Senator Westrom, you are correct about the process we normally go through, and I guess I'll have to get used to being back in this position here running the meetings. So although I do object to your characterizing my questions as grilling, we'll leave that in the opinion of the beholder. Senator Holmstrom, would you please describe your A4 amendment for the committee and the public?
Thank you, Chair. Yes, this is in light of considering a bill that puts law enforcement and members of the public in more danger. I figured it would make a lot of sense to increase penalties for doxing these agents and members of the public. We are coming into this bill specifically increases penalties for doxing and disseminating personal information about law enforcement, and also creates the opportunity for that accountability for members of the public, which does not currently exist. Again, when we're considering this, we're looking at a time when there is a organized insurgency among the people of Minnesota, and specific actors, a small group of Minnesotans, have come together to chase, to try to track, to spread information and dox these individuals and these officers, and even individuals who are there protesting the other side of the aisle. This is dangerous. We've actually seen police vehicles were broken into, and personal information was stolen about agents that led to death threats on their families. Board Czar Tom Homan said that there's a 1,347% increase in assaults and over an 8,000% increase in death threats against agents. This is outrageous. Minnesota does not this is not what Minnesota stands for. We do not force agents to put their families in danger simply because they want to help keep Minnesota safe, especially agents that are coming here from across the country to help Minnesota. This is egregious. This is outrageous. And personally, we should reject the premise. But if we're not going to, we should at least offer extra protection so that they're not putting their families' lives in danger. Thank you.
Senator Port, what is your position on the
Thank you, Mr. Chair.
A4 amendment?
Having just seen this, I obviously don't have a lot of time, haven't had a lot of time to think about the impacts of this. I do have concerns that including everyone in this to this point is potentially a First Amendment violation. I will defer to the ACLU to talk more about that. I will also just say, we have heard this number 1,200 or 1,300% increase in doxing or assaults. We don't have reports of those. They're not being reported out. They're not being prosecuted. I think the last attempt to prosecute one of them was for throwing a sub sandwich, and that was thrown out of court. So I'm not sure that risk is real enough and high enough that we should consider creating a whole new set of crimes for everyone in the state of Minnesota, but I also, just got this in front of me, so would love to hear from the ACLU's opinion on it, but at this point, I would ask for a no vote.
Mr. Beeler, anything to add?
A few quick thoughts, Chair. Thank you. Yes, this is broadens the bill to protect about 5.5 million people, prohibiting the dissemination of their information and attempting to tie it to a true threat. But what we're going to see with this is the weaponization of those prosecutions. We have 87 separate county attorneys, all of whom could bring charges, even if they don't necessarily know that they're going to win. And we are concerned that the increase in prosecution would target the free speech of individuals. As we talked about, the underlying bill makes people safer. The bill does not make anything more dangerous. It's supported by law enforcement at various levels. It protects law enforcement from being misidentified or being thought to be a threat, and it protects our residents. It protects people engaged in protected First Amendment activity. It protects people who are in their neighborhoods merely existing, where the federal agents have sought to deploy tear gas and other chemical irritants. So no, I don't believe that this amendment makes people safer, nor do I believe it's compliant with the First Amendment.
Any discussion from members of the committee? Senator Westland.
Thank you, Mr. Chair. I certainly am concerned about people being doxxed, but I think I'm more concerned about the fact that a member of this body refers to people exercising their First Amendment rights as insurgents, as though they are somehow enemy combatants in their own country, people who are actively trying to engage in lawful public protest. And while you may not like what they say, they have the right to say it just as much as you do. Okay, these are not enemy combatants. These are people who are seeing their communities being terrorized and attacked by people in masks who feel no compunction to reveal their identities or their authority. And I would just add, in addition to that, on June 14th, we had someone pretending to be a law enforcement officer who assassinated one of our colleagues, attempted to assassinate another one of our colleagues. These people are running around. We have no idea anymore if somebody approaching you is actually who they say they are or not. And the idea that somehow having them in our state has made us more safe is nonsense. It has made us less safe. And if anything else, we all swore an oath to support the Constitution. And that includes supporting the right of people to assemble, the right of people to protest, the right of people to petition their government. Those are all the bulwarks of ensuring that our country continues to be the beacon on the hill that we claim it is. And I'm offended by the fact that you refer to people who care enough about their community to show up as insurgents. It's insulting, and it's really inappropriate.
Any other discussions on the A4 amendment? Senator Westrom? Oh, I'm sorry. Sorry, Senator. Is that? Done. Okay. Senator Holmstrom.
Thank you, Chair Latz. Senator Port, you had mentioned that you weren't sure that there was any actual credible instances of law enforcement agents being targeted by doxing, and of course there is. Just this week, it was reported that 3 people are facing charges for sending threatening messages to federal agents following ICE actions here in Minnesota. So obviously, it is a real concern. There already is law to defend people against doxing. That has not been challenged under the First Amendment and prevailed. So that doesn't really hold a lot of water to me. And of course, we know that when people are organized, when they're using forms of communication to track, to create their own lists, to create roadblocks and make Minnesotans less safe because of their political ideology. That, of course, is an insurgency. It is domestic terrorism, and it cannot be accepted by this chamber or by any member of government. Thank you.
Mr. Chair, if I may.
Senator Port.
I think that Senator Holmstrom raises an interesting point about lists of people being created and being followed and being their homes, having video taken of them, pictures taken of them through means of communication that they're not supposed to have access to. ICE is not supposed to have access to our DVS information, to our license plate information. That has been litigated and discussed ad nauseum. Yet I have been followed home. I have had ICE agents parked outside of my home. I have had ICE agents walk around my yard taking pictures of my house. I haven't broken the law. I haven't impeded an investigation. I haven't even gotten out of my car at an ICE interaction to be on any sort of list for any sort of reason. So I think there is real danger to people creating lists of our community members, to intimidating them, to following them home, doxing them among their own friends and like-minded people. I think that is a risk. I'm glad that we have laws that address that. I understand other laws, other bills are being brought forward to address this as well. I don't think my bill is the place for this. I hope those conversations continue, though, Mr. Chair, and I hope this committee takes them up.
Senator Westrom, to the A4 amendment.
Mr. Chair, to the A4 amendment, earlier this week, members of the State Justice Department, some judges included, were in my office. And one of the key things they were bringing up and looking at this session is how they address security issues as well. And doxing is one of the issues that they in the judiciary also are concerned about. And this is a difficult balance, but this has become a growing area that seems like protesters or others that are intending to create fear or harm or do harm, but just the intent to create it is a powerful force by many of these protesters that we're seeing go over the line. And the judiciary, this is a real issue also for them. And so I think this is a very ripe time for us to start dealing with this. And it should be enhanced and a bigger concern that we deal with. So people aren't following people home. And the Supreme Court Justice said that they're even seeing some more and more of this. They're talking about ways that they can address this concern. I was even a situation in my district with one of the judges that's had a drone sitting 20, 30 feet out of their front door. They shared with me. And still do not know where that drone came from, but apparently was lit up well enough that they could see it. And so obviously somebody figured out how to dox this judge and show up with a drone that close to that the judge was able to see it when she got up and was helping her children in the morning. And so I think it's time. I would urge members to support this amendment, and this bill is going to be laid over, and I think it's a ripe topic that needs to be addressed at the same time. Then I have another question for the bill after the amendment, Mr. Chair.
Senator Westrom, if you wouldn't mind, I actually have a question for you, since you had a chance to meet with the judges on this, as I have, on issues of judicial security. You know, there are a lot of parts of the law where we carve out special protections for certain categories of people. Doxing for law enforcement, special protections for judges and prosecutors, and so on. Certain categories of employees have enhanced penalties for assault, for example. So, I mean, that's not unusual. We take a particular category of people who are facing a very special risk because of the kind of work that they do, emergency responders, for example. It's a greater criminal penalty to assault a law enforcement officer than it is to assault someone else, and so on. Are you at all concerned about the breadth of this amendment where it would create a criminal penalty for every Minnesotan to engage in the dissemination of personal information?
Well, Mr. Chair, I'm concerned about the bill.
I'm asking about the A4.
And the amendment. There may be improvements to the amendment as well, but I support the idea that we need to get more serious about people that use doxing as a way to intimidate, create fear, or bring harm to somebody. And so I think what we've seen recently, we've got to get more serious about it.
Senator Holmstrom.
Thank you, Chair Latz. To that point, actually, I think it's fair to point out, before I was elected, just earlier last year, I was a victim of doxing and obviously death threats and all that come along with it. And until I got elected to this body, there was no protection for me from that, because this body a couple years ago took up the decision to protect themselves, but not the general public. I think the general public absolutely deserves to be protected against this type of violence and this type of incitement. Thank you.
You know, there was a story in the news yesterday about a different bill in the other body, and the leader of the GOP in the other body said they weren't gonna, they all voted against the proposed amendment because they were surprised by it and didn't have an opportunity to consider it or evaluate it. And it was a pretty, I don't know what the amendment was even, but that was the reason he gave for his party all voting against the proposed amendment. I'm actually concerned about the breadth of this amendment and the unintended consequences that we haven't had a chance to vet. This is a really broad amendment, and there's no testimony being offered. There are no witnesses coming forward to talk about it. There's no input from stakeholders like law enforcement or other than the ACLU that happens to be sitting here on the bill, from all sorts of others who might have input on this, so I'm really feeling poorly educated on the ramifications of an amendment that's this broad. So, I mean, we can certainly consider whether to add it to the bill or not, but given especially some of the objections that were raised to some of the earlier bills that were concerned about stakeholder input and unintended consequences, I think it's premature to consider this broad an amendment at this time before the committee. But certainly it's up to the author of the amendment if he wishes us to go forward with consideration. Senator Wesley.
Well, briefly, Your Honor, I think what would be to Your Honor, geez, all the lawyers are back in session now, and we have to get this,
Yes.
Mr. Chair and Your Honor.
Senator Wesley. Counselor.
You know, I think based on the comments that you've just made, I think it would make more sense to have this drafted into an actual bill. NCSL is always a great resource to find out what other states are doing, what their other laws look like, to see how other states have addressed issues. And, you know, my friendly suggestion, as such as it is, would be to have this drafted as a bill and present it to the Judiciary Committee with stakeholders and make sure to get input from research and counsel to ensure that this isn't a bill with significant unintended consequences. But I certainly would not be voting for this today.
Whatever direction Senator Holmstrom goes with this, I'd also think it'd be helpful before I'm comfortable voting on it to know what fiscal implications there might be and what implications there might be for jail or prison capacity, given the new crimes that are proposed to be committed here. Senator Holmstrom.
Senator Latz, to that point, I am certainly willing to consider this as a standalone bill. If I do so, can I get your help or at least your commitment to seriously consider it and allow it to come back to this table to be discussed?
Well, Senator Holmstrom, I will seriously consider every bill that gets referred to the Judiciary Committee, and we do what we can to consider them back at this committee table for discussion. I'm not going to promise to give any bill a hearing, but certainly happy to sit down and talk with you about whatever proposal you make. If you introduce a separate bill, we'll take that as it is. The GOP knows that I don't apply a partisan screening to whatever bills get brought before this committee. So I'm certainly willing to have those conversations with you. And maybe we get some more information and some more fiscal information and some more stakeholder input. I'm happy to consider it at that time. Yeah, I'm certainly not ruling it out of hand and saying, no, you come back, we're not going to hear it. I'm not going to say that because I don't think that's appropriate as a chair to do that. So, Senator Holmstrom.
Thank you, Chair Latz. With that, I will happily remove this amendment, get a fiscal note, and bring it back. Thank you.
Senator Holmstrom withdraws the A4 amendment. Is there any further discussion before we, Senator Westrom, you wanted to talk to the underlying bill, is that correct? Senator Westrom.
Madam Chair, just to the author, under this statute, what's your understanding? Who decides when they get to wear a mask or not? Is it the individual that is the statute applies to?
Senator Port.
Thank you, Mr. Chair. Thank you, Senator Westrom. Like all of the statutes in our books, I think each person makes their own personal decisions to the best of their ability. I don't think there's any statute at which a police officer stands outside your door and says, yes, you can do that today, or no, you can't do that today. We have to make our own decisions based on the law.
And Madam Chair, or Madam Chair,
No,
sorry.
Madam Chair.
Your Honor.
No, I'm Your Honor. It's getting pretty confusing in here, Senator Westrom.
Mr. Chair, Madam Author, I should say, Senator Port. So I'm even wondering why we need your legislation, but two parts of your legislation. One is giving or the safety of the officers. So how would that not be allowed to the same practices we're seeing today? I assume most officers are wearing it for their safety for one reason or another. They might be wearing it for warmth in the cold weather, but isn't the current statute already allow that for officers?
Senator Port.
Thank you, Mr. Chair. Thank you, Senator Westrom. I think we are defining when those situations are true, because none of the Minnesota officers, none of the state troopers, none of the MPD, St. Paul Police, my own police in Burnsville, they're not wearing masks right now. They're out in the same streets that the ICE agents have been out in these last days, in many cases, far too many cases, in my opinion, helping to protect those ICE agents from perceived threats. And they haven't felt the need, even if they're standing between the ICE agents and protesters, have not felt the need to wear masks to conceal their identity. If they are, as you can see in the language, a member of a tactical response team, which we have sometimes seen on our streets in the riot gear, that is an appropriate time to wear a mask. If you're driving down the road in a suburb, waiting at a school bus stop, I don't know what the threat to you would be. Our local police don't find a threat driving our own, neighborhood streets. So I think this makes more specific when it is appropriate for a law enforcement officer, no matter what law enforcement agency you're from, when it is appropriate to conceal your identity. And there has to be actual serious, a known risk. Like, you're not just always driving around with a mask on because you could get in a car accident today, and so that's a risk, and so you better wear a mask. Like, that's not an appropriate response from our law enforcement in this country. We don't have masked police in this country. We never have. We should not start now. It erodes public trust. And so this puts the specific places where it is appropriate for law enforcement to wear masks.
And so, Mr. Chair,
Senator Westrom.
Senator Port, kind of review for us then what your specific intent is for which officers, undercover officers, tactical. They're the only ones you're saying would have an exception to wear a mask, except for the prior provisions up above that?
That's correct.
Senator Port.
And
Senator
so,
Westrom.
Mr. Chair, Senator Port, how would the first provisions not probably apply to all the officers just like they would apply to citizens in the state? Because, I mean, even now, when you still, there's still people that drive in their cars with masks. Presumably, it's maybe related to COVID or health concerns that they have. But officers could have that same concern. So does your bill really stop masks?
Senator Port.
Thank you, Chair Latz. This continues to provide the same allowances that it did before. I think the reason that we had to bring this forward, I agree, this bill should be completely unnecessary. It has never been a problem with any of the law enforcement who have been acting in the state of Minnesota for decades. It's never been a problem that we had to bring up and address. But we have an entire force of agents who all chose, with almost zero exceptions, to conceal their identity. That is a significant change. They clearly do not care that this law is on our books. So we have to specify that it means all people in Minnesota, all law enforcement in Minnesota, regardless of your agency. I wish that we didn't have to put these bills into law, Senator Westrom, but we have a federal government that is choosing to not follow our laws. So maybe we need to make them more clear, and that's what this bill aims to do.
Senator Westrom.
Well, Mr. Chair and Senator Port, how ironic, because it was this same statute that I used to walk around in 2020, 2021, 2022, reminding people, and most Democrat members ignored this law, and in many cases, they were mandating citizens who could make otherwise their individual choice, mandating them to violate this law because they were impugning on them that they have to wear a mask because they're going to force them to decide that there was a medical reason they need to, which we've now later found out was flawed logic and not scientific based, as we saw. But the boxes the government sent out through our chambers that I have in my office or had in my office literally said won't protect you from COVID-19, yet they were mandating us to violate the law to do this. So my point is, it's kind of ironic how all of a sudden 5 years ago there were people in your party and probably you as well wanting everybody to wear masks, and now all of a sudden police officers are enforcing the law, and now we want to say, oh, you can't wear masks, even though just a few years ago we were violating the law and telling everybody, including the governor, that you must wear a mask. And they should have repealed this law at the time so everybody at least wasn't violating the law. But my point is it's an individual choice, as you answered in my first question, and I think that's where we should leave it. I think the current law covers it. If officers want to wear them for a variety of reasons, including weather or health, they would have those provisions.
Mr. Chair,
So
if I may.
I just think it's ironic. Thanks.
Senator Port, final comments before we lay this over.
Yes, thank you. Senator Westrom, those provisions are still allowable to officers. Nothing in this changes those abilities to use those first provisions. And I will also remind you that I am a person who has been blessed with a permanent disability because of COVID-19. There are people in this body, there are people in this state whose lives were changed because of that, and it is a provision in the bill that allows people to wear masks for medical safety. I would ask that we treat our colleagues with some respect if we're going to call people's medical conditions hoaxes and lies. And I would, Mr. Chair, turn our attention back to the issue in front of us, which is that for the last 3 months, our communities, our neighborhoods have been flooded with masked men in often jeans and t-shirts and hoodies and a tactical vest you can buy on Amazon. We don't know who they are. We are a state that had a man pose as law enforcement and assassinate an elected official, her husband, and take aim at 2 other people. He was wearing a mask. We have community members who do not feel safe to leave their houses, to go grocery shopping, or to go to work. We have an economy that is being affected on many levels because of this flood of agents hiding their identities, terrorizing our communities. And we were called insurgents earlier in this conversation, and that's not the first time that that's been tossed around. And I will say, we had a conversation about this in my subcommittee when we talked about the tactics of immigration enforcement in our state. And I will say they said they're here because there's an insurgency, and they can't leave because there is an insurgency. And the insurgency that these agents have run up against is moms in minivans. It is pastors and imams and priests and rabbis with food deliveries. It is union members and neighbors with whistles. It is grandmas with Costco cards. And if that's what this administration and our colleagues across the aisle want to call insurgents, then I guess I'm a proud insurgent. I am proud of the way that our community, our state has stood up to terror of masked law enforcement. It is an unacceptable future for our state to have that be normal. I am proud of our country. I'm proud of our state. We don't allow masked law enforcement. We shouldn't start now. Secret police have no place in Minnesota and no place in this country. And I thank this committee for its consideration. And I hope you will consider debating and discussing this bill along with the other bills you've taken up today. Thank you, Mr. Chair, for bringing this topic forward.
Thank you, Senator Port. Senate File 3590 is laid over. We are joined now by Attorney General Keith Ellison, if you'd like to come forward and provide us with your testimony. Mr. Attorney General, welcome to the Senate Judiciary and Public Safety Committee.
It's an honor to be here, Mr. Chairman. And Mr. Chairman and members, it's really, really important for us to be having this critical conversation right now. If the reports from the federal government are to be believed, Operation Metro Surge should be winding down soon. Tragically, as it winds down, whenever the real end to this situation does come to an end, it will come too late for Renee Good, for Alex Preddy, and all who love them. We will continue to seek justice for them. The surge will come too late for Liam Conejo Ramos and other children who have to live with the trauma of their detention. It'll come too late for everyone who was wrongfully and illegally detained. It'll come too late for Minnesotans who have endured racial profiling, for businesses that have closed, for children that couldn't go to school, for people who've fallen behind in their rent because they couldn't get safely to work. The unprecedented, unconstitutional, and unnecessary exercise of force that is Operation Metro Surge leaves a lot of pain in its wake. Despite this pain, when the surge ends, it will be a victory. It'll be a good day. It'll be a victory for the rule of law, and it'll be a victory for the power of creative, lawful First Amendment activity, and for the strength of unity over division. Minnesotans organize themselves. They exercise their legal rights to observe and protest by the tens of thousands in subzero temperatures. They help their neighbors who needed help. And in the face of massive display of force and acts of intimidation and violence, they held their and our constitutionally protected ground, bravely, creatively, peacefully. I promised during this surge that I would do all I could to match Minnesotans' bravery. My office and I did a lot to hold ICE, DHS, and the Trump administration accountable for the rule of law and the Constitution. On January 9th, just 2 days after the death of Renee Good, my office joined forces with the Hennepin County Attorney's Office to create a portal for witnesses to submit evidence. This was necessary because almost immediately after ICE agent Jonathan Ross shot and killed Renee Good, the federal government made the extraordinary announcement that it would not include the state in its investigation or share evidence with state investigators. Mr. Chairman, you have been knocking around the courts of this state for a long time, and you are very well aware that it is entirely normal and routine for state law enforcement officials to work with federal law enforcement officials, whether it's the FBI, ATF, DEA, you name it. We work together routinely. Task force are usually and generally made up of both state and federal law enforcement officials. The decision to cut state investigators out was extraordinary. On January 12th, we had to file a lawsuit in federal court to end the surge. We argued and continue to argue that the surge is unconstitutional, violating our First, 10th Amendments to the Constitution and equal sovereignty principle. On January 15th, my office took the extraordinary step of having to launch a form on our website for Minnesotans to share the impact of federal government actions, including DHS actions, and the impact on them personally and people close to them, and to gather witness information because, again, we were not getting cooperation from that we were used to from our federal partners. To date, we have 1,500 submissions. And then on January 24th, the day Alex Preddy was killed, my office did something that it never had to do before. Representing the Bureau of Criminal Apprehension, we filed a lawsuit along with Hennepin County to compel the federal government to preserve evidence, something that would be unthinkable. We won a temporary restraining order within 2 hours after we filed it. Disappointingly, the FBI announced that it would not cooperate with the Bureau of Criminal Apprehension in the Preddy matter either. Again, these investigators are not political. They are professional investigators, very used to working with federal authorities, and they have been told by their local federal attorney counterparts, it's not our call, but they won't let us. And that's sad. So allow me to make clear that although the surge is winding down, 2 lawsuits we filed during the surge continue. We will continue challenging the constitutionality of the surge so that this administration or any administration cannot ever again attempt to compel a state to kneel to its policy demands, and that we keep fighting for truth, accountability in the killings and the other illegal actions or questionably illegal actions. Minnesotans had a right to expect that their federal government would have a credible, rational basis for sending 3,000 federal agents to our state for the largest immigration enforcement action in our nation's history. The federal government has never deployed as many immigration agents to one place at one time as it did right here in our very state. Instead, every rationale the administration has offered has been a pretext. The government has said that the purpose of the surge was to fight unauthorized immigration, yet Minnesota ranks 28th among all states in the percentage of undocumented immigrants. Florida and Texas alone have nearly as many undocumented people as the entire population of the state of Minnesota. The federal government has said the purpose of the surge is to fight fraud in government programs. I'm actually fine with that. I abhor fraud. My office is already in this fight. We've convicted over 300 people of Medicaid fraud in the last 7 years. But the government did not surge forensic accountants, computer scientists, who could actually help us in this fight against fraud. Instead, they sent 3,000 masked armed men. In fact, the surge has harmed the fight against fraud in Minnesota. Because of it, the federal government's work in fighting fraud in Minnesota has ground to a halt. The surge has triggered a wave of experienced prosecutors resigning from the U.S. Attorney's Office in Minnesota, and the remaining staff are drowning under a flood of habeas corpus petitions connected to immigration issues. The government has also said the purpose of the surge was to fight violent crime and rid our streets of the worst of the worst. Yet violent crime in the rates in Minneapolis were falling before the surge. Furthermore, ICE's own data shows 67% of those it has detained in Minnesota have no criminal record, and only a very small percentage have a record of committing violent crime. Notoriously, some of those detained have been children. 5-year-old Liam Conejo Ramos, the worst of the worst. 10-year-old Elizabeth Zuniga Gaseguano, the worst of the worst. And also, I don't know what the current status numbers are up to this day, but for several days this year, the federal government committed 2 of the homicides that were out of the 4 that were committed in the city of Minneapolis. Half. So it's hard to say this is about the worst of the worst. The federal government has also said the purpose of the surge is to gain cooperation from state and local officials and immigration enforcement. Now, the fact is, this is a late justification that happened after Metro Surge began, but I want to be very clear. Under Minnesota law, we have complied fully with the requirements of the law. The Minnesota Department of Corrections is already following state law. Section 631.50 requires that it inquire into the nationality of everybody convicted of a felony, and that it be reported to immigration authorities. And that when a non-citizen is convicted of a felony near the release date, that information be transferred. That's happening right now, and even the federal authorities have to acknowledge that, have acknowledged that. The federal government had to back off their false claim to the contrary when the DOC presented them with the facts. Now, Minnesota sheriffs and county attorneys already comply with state law that they may not keep someone incarcerated on an immigration detainer longer than they are otherwise legally allowed to incarcerate them. In February 2025, I did issue a legal opinion that restated the law, which is supported by a noted Minnesota case called Esparza versus Nobles County, as well as other cases from other states, which clearly state that if after a person were duly released, they were then retained, that would be a rearrest, and there has to be a legal justification for it, and which, if we were to do so, would subject counties to liability. When I met with Border Czar Tom Homan in person, he acknowledged that this was the law. So Minnesota is not, this surge isn't because we weren't following the law. We absolutely were. And so I can only come to one conclusion, Mr. Chairman, and after looking at all of the offered reasons and coming to the conclusion that they're not supported by the facts, I can only conclude that the surge is about what President Trump said it was about. In a Truth Social post on January 13th, he wrote, quote, "Retribution and reckoning," unquote, was coming to Minnesota. Operation Metro Surge was Trump's retribution for our policies, our values, and how we vote. So, Mr. Chair, I will stop right there, but I will say that I think that the bills that are under consideration have a lot of merit, and I support them. Duty to render aid is a solid, good piece of proposed legislation. The mass prohibition as well. I appreciated the dialogue that happened in the previous session, this previous moment. Protecting essential spaces, very important. Minnesota Constitutional Remedies Act, I support that. And the BCA Participation in Federal Investigations Act, I think all are meritorious pieces of legislation. And I would hope they would get bipartisan support, because at the end of the day, I'm urging conservative behavior here from our legislators. Let's conserve the Constitution. Let's conserve the Constitution. There's nothing wrong with conserving what is right to conserve. So with that, I'll stop.
Thank you, Mr. Attorney General. I understand we have you until 1:30. Could you stick around if there are any questions or conversation? Members, just a heads up. We're not going to talk about the Attorney General's office operations or their budget or their staffing. Stuff like that is appropriate for the State and Local Government Committee, but not ours. So if we can just stay focused on the topic of the day, I'd appreciate it. Senator Kroon.
Thank you, Mr. Chair. Thank you, Mr. Attorney General. You mentioned the Esparza versus Nobles County case, and your Attorney General opinion, which in your view is restating Minnesota law, and you talked about how we in Minnesota are following Minnesota law, and Mr. Homan acknowledged that. So that's where I'm picking up from.
Understood.
Thanks. So when we look at that Esparza versus Nobles County case, the court does talk about how the legislature knows how to draft legislation to cooperate with the federal authorities. And it says, because the legislature has authorized state and local officers to cooperate with federal immigration officers, but has not authorized state and local officers to detain or execute federal immigration warrants, we conclude that Minnesota statutes do not authorize the appellant's seizure of respondents based on ICE detainers and warrants. That is ultimately the conclusion of the court. So my question is, what's preventing the legislature from expanding Minnesota law so that we may have a brief detention, so that we can do some of this immigration enforcement in a controlled environment like a jail, in a more measured way, in a safer way, and reduce street level enforcement?
Mr. Attorney General.
Mr. Chairman, well, first of all, far be it from me to tell the legislature what it should do. I think it's a worthy debate for you all to have. My opinion would be this, just off the cuff, because I'd like, if you all actually take that up, I'd like an opportunity to do some real research on the issue. But I will tell you this right now. I think constitutionally, once a person is released from their state detention, the reason that they were in custody in the beginning, once that's over and the state court judge said, you can go now, detainers are now and have always been regarded as a request. They're regarded as a request. So now if the legislature passed a law that said we're going to detain you beyond our purposes as a state, I think that you still may have to figure out how you get around the Fourth Amendment problem of holding somebody who you don't have any probable cause to hold simply based on a federal detainer, which even the feds will recognize as basically a request. I actually think there's other ways to do things. One thing that could happen is that the immigration authorities just got to get there on time. Now, you probably followed the Cottonwood Sheriff's matter. I don't know if you saw that. But I mean, the Cottonwood Sheriff, who's no bleeding heart liberal like me, and I'm proud to be one, y'all know that, He said, hey, look, I told them that they were here, come get them, but he didn't get there on time. The federal government has to share some responsibility here. They've got the biggest budget. They got a budget bigger than the Marines. I would think that they should get to where they're supposed to be on time. So I do encourage you all to have that debate. If you have it, I'll offer my views on it with all due deference to the legislative prerogative.
Senator Croon.
Thank you, Mr. Chair, and thank you for that response. And there isn't just one way to get at this problem. And certainly there are Fourth Amendment implications that we're going to have to take into consideration. But my larger point is that it does seem, at least with respect to the jails, not necessarily the prisons, that there does seem to be a lack of cooperation at times that is not allowing for some of these detentions to take place in controlled environments like a Sally Port in a jail, and that the legislature does play a role in advising and passing legislation so that that can be done in an orderly manner. And yes, there are multiple ways to do it. I'm looking at other ways to do that as well. And also we have the issue of communication, the BCA, the switch that everybody talks about, and making sure that those electronic messages to the federal authorities are sent and received so that we can have better communication, so that the federal authorities can respond quicker to people that they haven't come and take. But the larger point is this: we need to cooperate more, not less. We need more cooperation between state, federal, and local officials so that we can do this law enforcement in a way that reduces street-level enforcement and does it in a controlled environment. I think that's better for the state of Minnesota. I think that's better for everybody involved. That's where my efforts are going to be, and I look forward to working with you on that.
Mr. Chairman, could I briefly respond? Of
course.
So I appreciate that, Senator. I really do, and you know my door's always open. I look forward to talking to you about this. On the issue of cooperation, I think that everybody ought to cooperate with everybody. Cooperation is generally a good idea. And I wish that the feds would cooperate with us on these criminal investigations. I mean, I hope you agree with me on that. I mean, pretty good. We got dead Minnesotans. Look, I have charged law enforcement officers who committed crimes, and I've declined to prosecute them when there was no case to charge. I've declined more than I've charged. So I don't mind declining a case when when we cannot support a prosecution. But I do urge all of us from both sides of the aisle, there's nothing wrong with a joint independent investigation in a homicide. And if we all said that together, imagine the message we could send together. Some people in Washington might be surprised to hear Republicans say, you know, I think we should, you want cooperation here, what about cooperation there? But let me also caution you on one thing, and this is just something for you to think about as you go forward. When somebody is in a jail and they're pre-trial, haven't been convicted of anything, they're picked up. Now, to hold them longer than the state has a right to hold them is a rearrest. We've got to figure that out. That's a Fourth Amendment issue, which means that it could be unconstitutional if you write the law wrong. But here's my point and what I'd like you to consider. Let's just say we think that you are not lawfully within the United States, you're not convicted of anything, but we're going to call ICE on you now. Let's say we did that. I'm not proposing that. I'm offering that as a hypothetical situation. Now, if that were to happen, imagine a 15-year-old rape victim who has said, that man assaulted me. The police arrest him. Maybe bail is, all offenses in Minnesota are bailable by constitutional right. Now this person somehow gets out. We tell them, and now all of a sudden they're back in their home country and have never had to face justice for what they did. So as we talk about cooperation, the federal government has to respect the fact that the state has an interest in prosecuting criminals and can't just deport them before they've gone through due process. And it's quite possible maybe the person didn't do it. maybe mistaken identity. There might be other defenses. But to just say the federal and immigration enforcement interests trump that of the state, I would hope, again, all of us, Republicans and Democrats together, can say, no, Minnesota justice is going to play out. So thank you, Senator.
Thank you, Mr. Attorney General.
Real briefly, Mr. Chair. Real briefly.
Senator Kroon, real briefly.
Thank you, Mr. Chair. I appreciate that. And the situation that you just described there is actually one that has been brought to my attention by the Anoka County attorney where I live. And that is a real issue. And I do think that victims of crimes should have their day in court, and there should be cooperation between local, state, and federal officials in that regard too, and in a whole host of things. So I think, you know, if that's a overarching thing that we can agree on, maybe there's some work that we can do together on that.
Let's talk soon. Thank you, Mr. Chairman.
Sounds like we've got some cooperation in the works here.
See?
Thank you, Attorney General Ellison. Appreciate your testimony here today. All right. The remaining two bills are ones of which I am the chief author, so I'm going to ask our Vice Chair of the committee, Senator Verbaeten, to take the gavel, and I will go to the testifier table.
Senator Latz, did you have a preference for which bill you wanted to start with?
Madam Chair and members, I was looking to see if Superintendent Evans is in the room yet, as he's a witness on Senate File 3660, so I just as soon do that first if he's available. He's listening outside, apparently. I don't know, that BCA surveillance is pretty pervasive. Listening to the Senate media broadcast in the hallway, probably. Yes. Madam Chair, I'd like to take up Senate File 3660, please.
Okay, go ahead. I know you have a author's amendment as well, so I'll let you share the bill and the author's amendment with us.
Thank you, Madam Chair. The bill basically mandates that the BCA's use of force investigations unit conduct law enforcement officer-involved death investigations, as well as criminal sexual assault investigations relating to National Guard and law enforcement officers within their current statute, and this expands that to include mandated jurisdiction for officer-involved death and criminal sexual assaults involving federal agents employed by DHS, ICE, Customs and Border Protection, or the Citizenship and Immigration Services. The author's amendment clarifies the definitions of federal agent and also clarifies the effective date to cover deaths which occur on or after December 1st, 2025. So I move adoption of the A1 author's amendment.
Thank you. Senator Latz moves the A1 author's amendment. All those in favor say aye.
Aye.
Opposed? The motion prevails and the amendment's adopted.
Thank you. I'd ask the committee to hear from Superintendent Evans, please.
Okay, Superintendent Evans.
Thank you, Madam Chair and members of the committee. My name is Drew Evans. I'm the superintendent of the Minnesota Bureau of Criminal Apprehension. I think I'd asked to speak just a little bit about this. As many of you know, in Minnesota, the BCA employs a force investigations unit, and the entire purpose of this unit was created with a lot of bipartisan support as we work through how we approach officer-involved shootings, in particular, use of deadly force cases in Minnesota, to ensure an independent, unbiased, complete investigation into these matters. That unit operates independently. We do also criminal sexual conduct investigations involving Minnesota peace officers and Minnesota National Guard members where the subject is a Minnesota National Guard member and the victim survivor is a Minnesota National Guard member. That unit's been in operation for a few years now and conducts those investigations across the state of Minnesota. I think talking to some of the aspects of this bill, the requirements in the bill as now as defined, it requires us for any officer-involved shooting where a individual dies as a result of the officer-involved shooting. That statute applies right now to only Minnesota peace officers. So federal law enforcement were not defined under this particular statute. I will note for the committee, and happy to answer any questions for you, in the past, the normal course of practice with federal law enforcement officer-involved shootings is that an organization like the BCA, in the past there were different ways of doing this, but we've done a number of federal investigations at the request of federal authorities. These last three incidents that you've been talking about, that's how the first incident really started with Renee Good and was disrupted in that process. I think what this bill attempts to do is provide clarification that this applies to all. I do want to note a couple things for people as you're contemplating this, because there's been a lot of discussion about this in the media, nationally and locally. A thorough investigation, both looking at the state aspects of our state laws and how they apply, and also by federal authorities in a color of law or different aspects they'd be looking at, provides us the clearest picture and most thorough examination of one of these incidents when they occur. We both look at these from a little bit different perspective, and that's why historically you'll either see an entity like the BCA conduct an investigation and provide their case file to federal authorities, whether it's their Office of Professional Responsibility or the FBI if they're looking at it from a civil rights violation perspective, and then we get a most complete picture. The BCA does not do investigations and provide recommendations to prosecutors. We simply get to the truth as to what occurred, gathering all information, evidence along the way so that we can provide that to the appropriate prosecutorial authorities to make a determination. When we do that, we do not provide a recommendation to that prosecutor as to whether or not we have a belief if it's justified or unjustified. We view our role and continue to view our role as simply trying to give the most complete picture in this instance so both state and federal prosecutorial authorities would take an examination of those facts to determine whether or not there were any state laws in our instance that may or may not have been broken, and if there's any federal laws may have been broken as well when you're looking at it from a federal prosecutorial perspective.
Thank you. I had just a few questions for you, Superintendent Evans, and then I'll definitely open up to the committee. So my understanding is that in situations where we've had an officer-involved shooting, the local law enforcement here in Minnesota, BCA shows up to the scene to secure the scene, gather that evidence. And so that is what our local law enforcement sort of used to as the process. Can you share more about what took place during the Alex Preddy shooting, Renee Good shooting? Did BCA show up to the scene with an intention to secure the scene and gather evidence alongside the FBI, or to just kind of what is the practice there? Do you view your role to be the first folks on the scene, or do you defer to the FBI? And then I'll have some follow-up from that.
Thank you, Madam Chair and members of the committee. It really can depend, depending on the process. I want to be clear for everybody that the FBI is and remains an excellent partner for all types of investigations that we conduct and continue to. Even although we've had, challenges working through this driven by the Department of Justice, just this week we are out executing warrants with the FBI and remain a partner on different matters. When it comes to these particular cases, the Renee Good, there was a little bit of delay in terms of deciding on a joint investigation to begin with that. So the FBI had started processing that scene. Obviously, they're a very competent investigative agency and can conduct those investigations. We do things a little bit differently on certain things, and so in that case, we originally had intended to do some further scene examinations that are much related to how we process officer-involved shooting investigations. We do have a pretty, we have a protocol that we follow in all cases, including our crime scene team, that it's an internationally accredited crime scene team with our laboratory that does the examination of the scene. That investigation then, there was inability to hold that scene at that time, and so the vehicle was towed. We have expressed an interest still to this day to process that vehicle, which is still part of the discussion that we have ongoing with them. And as you've seen, it's been announced by the Department of Justice that investigation is not proceeding with in terms of the use of force by that officer. In the second investigation that was referenced, which was in North Minneapolis, in that particular case, we had an intention at that point in time to go and process that scene together. It did become dangerous at one point for everybody to be in that scene, so we had to clear. We did return as the BCA later on and did additional examination and gathered evidence in that particular case. In the third investigation, we were physically prevented from accessing, in Alex Preddy investigation, the scene, including when we did have a signed search warrant from a judge. However, we did also later on go back and process for additional evidence. In an ideal world, we would work this out and either do this together or the BCA typically would have our team close and often process the scene. We would share any and all evidence and any evidentiary examinations with our federal partners back and forth, each way sharing information, either jointly investigating the case or sharing information with each other. Certainly can be independent investigations of each other.
Thank you. Members, questions? Okay. I saw Senator Kroon and Senator Holmstrom. Whoever wants to go first. Senator Kroon.
Thank you, Madam Chair. Thank you, Superintendent Evans. Can you, I know that you said you don't provide recommendations for prosecution when you're doing this, and can you walk me through how your work and your investigation works, where there could be concurrent prosecutorial agencies that could decide whether to press charges? Does it change? Can you walk me through that?
Superintendent Evans.
Madam Chair, Senator Kroon, it's a really good question. So that's part of why we've been having the discussion ongoing about a joint investigation would be most ideal, but it doesn't need to be. In these cases, they're color of law. There's a number of they call them color of law investigations that they conduct on the federal when they're examining the conduct of a federal agent in this instance. But to be clear, when we've done joint investigations of local law enforcement, they're examining the same thing. There's a number of cases where we've done that jointly with our FBI partners in the Department of Justice, including Maine Justice Civil Rights, which is typically who reviews these. They have a number of elements that they're looking at, and they'll often need evidence that's slightly different that isn't actually relevant to maybe what we're doing, and going back further, examining past conduct of officers, et cetera, as opposed to the piece we're looking at. When on the other hand, federal agents are not peace officers in Minnesota and obviously are typically not well-versed in Minnesota law, in particular use of force statute. So we're gathering through our protocol a specific set of circumstances and information that we do in each and every case, and then that's looked at by the state prosecutor. I don't know if this is part of your question, but my understanding, and we do that without recommendation, but that's kind of been the position we've been working through with our federal partners trying to get to this, is that there are a number of complications that can develop after, say, a local prosecutor, here in this case a county attorney or attorney general's office makes a determination if they were to charge. Those cases will typically be removed to federal court, when then there's a number of procedural pieces that'll be done that between both the U.S. Attorney's Office and the county attorney or attorney general's office in that particular instance, which is outside the purview of anything we do. But we are gathering similar but sometimes different information along the way that are focused on those different investigations and the statutes that we're looking at.
Any follow-up? Senator Kroon.
Thank you, Madam Chair, and thank you for that answer. So if it ultimately, in a case where there's a federal officer involved shooting and the U.S. Attorney's Office, I don't know exactly how that works in terms of if they can assert they're going to be the prosecuting agent over the Attorney General's office or the state or the county attorney. But from your perspective, you're saying that your investigation doesn't really change that much, and that you can be a partner with the FBI either way?
Superintendent Evans.
Madam Chair, Senator Kroon, yes, that's accurate. We can work together the same way we work together with the FBI when they're doing color of law investigation involving a local police officer. It really is the same concept. It's just the reverse in who is the individual that used the force. The only difference is the legal proceedings and how those may proceed. And they proceed in different ways, is my understanding, in talking to a number of prosecutors that have been advising on this, how they do that. But our approach does not change. It is very similar, and you examine the same statutes with that. One of the important components as to why these need to be investigated thoroughly is an important component to that legal proceeding portion of this is whether or not the use of force, deadly force in these situations is within the normal course and scope of their duties, which sounds easy, but it's a much more complicated legal analysis, which is not our legal analysis to do, but gathering those facts so that proper legal analysis can be done is what we're attempting to do.
Thank you.
Senator Holmstrom.
Thank you, Madam Chair. Superintendent Evans, you had mentioned during the Raina Engel Good investigation that at one point it was too dangerous to conduct the investigations. Can you please describe what specifically the threat to law enforcement was that stopped you from being able to do those investigations?
Superintendent Evans.
Yeah, Madam Chair and Senator Holmstrom, in a couple of the different cases, the crowd became to a point where we weren't able to hold the scene. I'll note that there was escalatory behavior that was occurring. There was a lot of tear gas that was being used with the crowds, and the crowd management got to a point where they were becoming challenging to hold the scene. And so that happens in different circumstances, not just here. And we're always telling our teams we're going to make a determination to ensure their safety while they're at the particular scene. And so in those cases, that there was a determination by our teams out there that they would come back at a different point in time.
Senator Holmstrom.
Thank you. Is it your position that deploying tear gas is an escalatory metric or a decision, or is it in response to escalation that's already happened?
Superintendent Evans.
Madam Chair, Senator Holmstrom, it really depends. That's a number of different circumstances. Our state teams, both, with our various state patrol, DNR, and the, police department that's involved in those circumstances, it really depends on where it is. They certainly use chemical to protect themselves, but we've learned through this state, through a number of different incidents that we've gone through, it's not always the most effective tactic in terms of controlling crowds, but there's a place for it when it should be used. I'm indicating in some of these cases it was used fairly indiscriminately. I was in the scene on the second one, and it was being used indiscriminately at that time.
Any follow-up? Okay. I just had another question for you, Superintendent Evans. And you walked through a number of different scenes, but you did mention after Alex Preddy was killed that the BCA was physically prevented from having access to the scene. Were you told why?
Madam Chair, members of the committee, we were simply told that it was a federal investigation being led by the FBI and we'd be prevented from accessing the scene.
And just to follow up, Superintendent Evans, because you have and are eager to cooperate, right, with the FBI, with federal partners, that was unusual. There have been situations where you would have previously been given access.
Yeah, Madam Chair, members of the committee, it's highly unusual. We cooperate each and every day on a number of them. Again, I want to reiterate, our local FBI field office continues to be excellent partners, and these are decisions that certainly weren't being made here or driven by our FBI.
Senator Clark.
Thank you, Chair. When you say highly unusual to be prevented, would you count that on one hand or two hands?
Superintendent Evans.
Madam Chair, Senator Clark, it's never happened. I've been at the BCA over 20 years, and I've not been prevented from accessing information that's relevant to our investigation. I'm hopeful through continued dialogue that we'll come to a point where we at a minimum can share information with each other. We want to do the same with them.
Thank you.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. And this maybe is for Senator Latz, but certainly Superintendent Evans can jump in too. I'm just trying to understand the intent of the bill here, subdivision 3, adding the federal agents part. Is this just to clarify, at least under state law, that that's an additional duty for the BCA? But I don't know how that would rectify the situation that Superintendent Evans just talked about, where the federal government says you're not welcome to do the investigation. So is it just your intent to just clarify what has been the existing practice for many years, to let the BCA know that from a state law perspective, this is part of your duties? Do I have that right, or am I missing something?
I just wanted a clarification, Senator Kroon, because I know there was the A1 amendment. Can you just tell us which part of the bill you were referring to?
Thank you, Madam Chair. I was referring to the as introduced subdivision 3, so it'd be line 2.5, which I don't think that the A1 changes that, because that just deals with changes the definition to federal agent.
Yeah, Senator Kroon, that was deleted in the A1 amendment. But did you have any follow-up, Senator Latz? Okay.
Nope.
I don't see any other questions or comments for folks, so final comments, Senator Latz?
Look forward to hearing this on its merits and taking action at a future hearing.
Thank you. With that, Senate File 3660 is laid over, and we'll move to Senate File 3699. When you're ready.
Madam Chair, Senate File 3699 prohibits the civil arrests of a person who is a party, a witness, a potential witness, or a court companion in a court proceeding while the person is going to, remaining at, and returning from those court proceedings. And that includes within court buildings, any location where the person accesses a court proceeding held remotely, any parking facilities serving the courthouse, on sidewalks or streets surrounding the courthouse, and on any public way within 1,000 feet of the courthouse. I emphasize that it's in connection with the person going to, remaining at, or returning from those court proceedings. The bill then defines civil arrest. To be clear, that it's relating to taking of a person into custody for an alleged civil immigration violation, or conducting a brief stop to serve an individual with a Form I-862, notice to appear, or other similar document initiating a removal proceeding. Civil arrest in this bill does not cover arrests for any alleged criminal violations of federal, state, or local law, or an arrest supported by a judicial warrant. It then establishes civil liability and damages for violations of the statute, or of the bill. I isolate the context as well, if I may. There's nothing more fundamental to the operation of our justice system than the ability to participate in it. This covers the participation in our judicial process. That means that people who are attending court in whatever capacity as part of the justice proceeding should not be detained, could not be detained from that participation. That's important not only for our accountability within our justice system, but also to protect victims of crimes that are allegedly committed by persons that are seeking to attend a court or proceed in court or be a witness in court. A justice action cannot be complete to protect the public, to seek justice for the victims, if those who are participating in the justice system cannot do so safely and without fear of civil arrest. So that is the purpose of this bill.
Thank you, Senator Latz. And we have some testifiers. So if Emmanuel Williams from the Legal Rights Center and John Beeler from ACLU can come forward. And you can begin just by sharing your name and title for the record.
Good afternoon to the Vice Chair, Committee. My name is Emmanuel Williams. I'm a staff attorney at the Legal Rights Center where I practice criminal defense law. In that role, I've seen the pros and cons of our legal system and what it creates. I've often seen those damages mitigated by our constitutional rights and due process. This bill provides a way to protect community members so that they can exercise their due process rights. Protection for those people, especially people of color, in courthouses is the utmost priority for attorneys like myself. I believe that regardless of status in the community, a human being should have access to high-quality legal representation and an equal opportunity to exercise their legal rights. To deny a person a day in court is to deny justice. Due process in our legal system should never be infringed upon. Currently, with ICE's enforcement not being limited around courthouses, we are seeing forceful removal of community members based solely on accusations that Attorney General Keith Ellison so eloquently put, could completely be false. To me, this constitutes a form of violence towards our communities, especially our communities of color, including Latinx. Additionally, many attorneys talk about the harm that a failure to appear to court by their clients can have, as there are many lawyers and law-adjacent people on this committee. I'm sure we've seen. So I believe that it is hypocritical to punish those who do not appear for court, yet provide no protection whatsoever for those who do want to attend court and exercise their right to rectify an incident in the community. Lastly, I will say to you that the protection this bill provides goes beyond just parties in the case. It extends to every person of color that is involved in a case. The kind of safeguards that provide parties the ability to fully show up and exercise their rights, but also interpreters, attorneys, witnesses, victims, and experts to show up fully as well. This bill provides protection to those in courthouses whose immutable characteristics cannot be altered by title or any sort of license. So I would urge you all to support this bill as it protects the very constitutional rights that we all took an oath to protect. Thank you.
Thank you. And Mr. Beeler.
Thank you, Vice Chair. Members of the committee, John Beeler, Policy Counsel at the ACLU of Minnesota, testifying today in support of the bill. Returns us to a policy that was in place for roughly 20 years, prohibiting immigration enforcement in courthouses except where the law enforcement has a warrant. Since the beginning of President Trump's second term, ICE and CBP have dramatically expanded their presence at criminal and civil courts, including in family, landlord, tenant, and traffic courts around the United States. The presence of these officers and increased immigration arrests have created deep insecurity and fear among our immigrant communities, and is stopping many from coming to court or even speaking with the police in the first place. The immigration enforcement at courthouses undermine the due process rights of all people present in the United States, and since it came up on an earlier bill, I'd like to remind the committee that the 14th Amendment to the Constitution is not confined to the protection of citizens. It says, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws." As one of the courts said in Plyler v. Doe, these provisions are universal in their application to all persons within the territorial jurisdiction without regard to any difference of race, color, or nationality, and the equal protection of laws is a pledge to the protection of and the equal protection of laws is a pledge of the protection of equal laws. According to an ACLU report from the first Trump administration, when they restarted some immigration arrests at courthouse, the results were dramatic. Immigrants were less likely to make police reports, less likely to help investigations, and less likely to work with prosecutors. More than 50% of the police officers surveyed said domestic violence, human trafficking, sexual assault crimes were all harder to investigate because immigrant crime survivors were afraid to seek assistance. Prosecutors said the cases are harder to prosecute. Judges reported court cases interrupted due to witnesses' fear of coming to court. When the federal government insists on conducting immigration arrests in courthouse, it is harder for prosecutors, police, public defenders, and judges to do their jobs. Immigrants, and with the increased use of racial profiling, people who look like immigrants are afraid to exercise their rights. We urge the committee to support this bill. Thank you.
Thank you. Any questions? Senator Kroon.
Thank you, Madam Chair. Maybe this would be for the ACLU lawyer that's.
Oh, don't go too far.
Or maybe Senator Latz. I mean, either one of you probably can answer the question, but I'm just, And despite Senator Champion crowning me a constitutional law expert previously, I don't know if I want that title, and certainly have not studied this issue, but I'm just curious whether or not there's federal supremacy issues with kind of dictating when and where, how federal immigration authorities can enforce immigration law. And if the courthouses are open to the public, does that create a problem from that perspective?
You got recent case law. Madam Chair.
Senator Latz.
Senator Kroon, if I remember right, I was just provided, but I haven't read it. Was it a California case from research where the courts in California concluded that the state has the authority to protect the essential operation of justice within their court system without running afoul of the supremacy clause. I think it's still at the district court level, but there may be those who know more about it than I.
That's
Mr. Beeler.
Thank you, Vice Chair, Senator. That's generally the approach with these bills, is that the immigration enforcement officers can access either with a warrant or with the consent, and the state has the ability to withdraw that consent within their property. That applies to courthouses, public schools, and other state-operated, state-owned buildings. And so that would, in this case, would allow warrant-based enforcement, but no further.
Madam Chair.
Senator Latz.
I would add this here prohibits civil immigration enforcement or violation as well. So it would not stop enforcement of criminal laws or criminal warrants.
Senator Kroon.
Thank you, Madam Chair, and thank you for that answer. I haven't had a chance to research it, so it was just a question to throw out there. I just flagged it as an obvious issue, and I don't know if the California case is on point or if there's going to be an appeal, or maybe it's a TBD kind of thing, but just wanted to throw that out for discussion, as it was kind of the obvious thing that came to my mind. Thanks.
Senator Holmstrom.
As I read this bill, it occurs to me that this seems like we're over-engineering a solution to a problem, which is that we've implemented sanctuary state policies in Minnesota, which has caused ICE and immigration enforcement to start looking in more obvious places and more difficult places. It seems to me, instead of creating new legislation to attack this problem, we just eliminate the root of the problem, which is the immigration sanctuary policies that we have here in Minnesota. I don't think that we need to put more Band-Aids on this. I think we need to take out the original cancer. Thank you.
So,
Senator Latz.
Madam Chair, Senator Holmstrom, your terminology is very, very broad. Just saying sanctuary policies doesn't actually have any definition that I'm aware of. And as Mr. Chishti indicated in his original presentation to us, individual local governments making decisions about the scope of what is and is not covered with regard to the levels of cooperation. And as Attorney General Ellison indicated, there are issues relating to Fourth Amendment search and seizure as well. The fact of the matter is that there are a lot of people who have run into ICE agents who are citizens, who are law-abiding, who have been stopped or arrested or detained regardless of their immigration status, regardless of having violated any laws, often just because they look like people of color. That's just the facts, and no amount of statements here in committee can change that. What is happening, in fact, is that crime victims are afraid to report crimes committed against them because law enforcement, or because of the risk of deportation of the alleged perpetrator. When people are charged with crimes and they have a court date, they are faced with the choice of going to court, risking being taken by ICE on their way there, on the front steps of the courthouse, in the hallways, in the courtrooms, I've watched it happen. It's happening. And if they are taken and deported, then the victim of that crime will never see justice. In fact, the person, if in fact a crime was committed, and sometimes they are charged with crimes that weren't in fact committed or the state would not be able to prove, and they get deported, when if they were convicted, they might have served time in jail, then in fact, the immigration action is a get-out-of-jail-free card by sending the alleged perpetrator out of the country if they're deported for a life of freedom in a different country. So the community's demand for justice in our criminal justice system, a victim's demand for justice when there was in fact a crime occurring, is completely undermined by barriers that are in place for participating in the criminal justice system. So for the operation of our justice system as a whole, participants in our justice system need to be comforted, need to know that they can participate without fear of being arrested on a civil immigration violation, or detained, I should say, on a civil immigration matter. So statements that go beyond that miss the point of this bill.
Senator Holmstrom.
Madam Chair, to that effect, I think we can all agree that we should have sympathy for victims and should work with them and help them find their justice. However, this bill definitely goes far beyond the victims. It goes so broad as to the court companions, which is a very broad definition. And I guess what's the defense of allowing such a wide description of court companions to be also included in these protections, inside or outside of court, or even on their way home?
Senator Latz.
Madam Chair and Senator Holmstrom, you know, I'm in court almost every day. So here I am already. I made my opening statement, said I'm a lawyer practicing law in court. But I bring that experience to my job here in the Senate. I will tell you that it is quite rare for a victim of a crime to show up in court alone. They show up with their brother, their sister, their father, their mother, their child, their friend. They show up with a representative from the office of the victim advocacy organizations that provide them support, strength, emotional comfort to come and to testify at a trial or to come and give a victim statement when there is sentencing. Because by state law, every victim is notified about court appearances in their case, and especially when they're sentencing, and they have a right to present testimony. It's not easy, and often they don't show. They might submit something in writing because it's too difficult. Witnesses that are not victims, it's still difficult because sometimes they're coming in and testifying as a witness against someone they know, someone in their same social network, someone within their community. They may be worried about implications beyond that courtroom. It's quite common for them to come with support, another person that will help them be an effective witness. There's a reason why court companions would be protected here too, because again, if you are creating a system that deters participation in the criminal justice system, then you are impairing justice itself. And that's why this is written as broadly as it is.
Senator Holmstrom.
I appreciate you even further defining that broad definition of a court companion. Here's my concern. A court companion or somebody is at a convenience store near a courthouse and they get stopped by immigration enforcement or a law enforcement agency that's in a 287G agreement. And they are found out to be not citizens here, and they go, well, I am a court companion. I'm a friend of you know, this individual that was in court. That we're on our way back from court right now, and the law enforcement officer is then, by your bill, open to, or at least the agency, to a civil action, damages up to $10,000 for that deportation action. It seems to me like the goal of this bill isn't purely to protect victims. It is to create an atmosphere where people can actually just get out of immigration enforcement in general. So is the goal here to actually help victims, or is it just to avoid law enforcement doing their job and deporting people, no matter where they're at, where they find them?
Madam Chair.
Senator Latz.
And Senator Holmstrom. This bill is about the operation of our justice system. Nothing more than that. There is a limitation in the bill of being within 1,000 feet of the courthouse or the place where they're accessing the courthouse. If they are, in fact, leaving the courthouse and they're within 1,000 feet and they stop in a convenience store, then yes, in our judgment, my judgment as a chief author, that will impair the ability of our justice system to operate. This is not about immigration policy, and this is not about impeding the enforcement of immigration laws. This is about the operation of our state justice system. And frankly, well, it's limited to the state justice system. I think it doesn't cover federal courts. Maybe I should ask counsel that question. I think it only applies to state judicial proceedings.
Ms. Primo.
Madam Chair and members, yes, the definition of court proceeding is at page 2, line 11, and it applies to state and administrative courts.
Thank you, Madam Chair.
Senator Latz.
Frankly, I think we might want to consider whether we have jurisdiction or ability to include operation in federal courts as well. But set that aside. The suggestion that this is for the purpose of interfering with federal immigration law enforcement has no basis whatsoever, Senator Holmstrom. Read the bill. It's very clear. And the purpose of this bill is to safeguard our criminal justice system. Nothing more, nothing less.
Any other questions? Okay, I'll go to Senator Holmstrom, and then following that, Senator Westrom.
Thank you, Madam Chair. Final question. So I come from outstate Minnesota. I'm sure you've been there as well. Many courthouses in Minnesota
I've driven through it.
Are in small towns, yeah. And there's a lot of small towns, 1,000 feet. There certainly are convenience stores. There certainly are grocery stores in these areas. And I suppose if your bill passes, they will see a boon of illegal immigrants choosing to gas up there and get their food there as opposed to the rest of the community, purely because this creates a, in my opinion, wildly broad protection for them and not much protection for law enforcement trying to actually do their job. Thank you.
Madam Chair.
Senator Latz.
Senator Holmstrom, if you've got a different number of feet that you think could be better to use to protect the operation of our justice system, I'm certainly open to have that conversation. But people who go to court have to leave court. And they should at least have a protective bubble of some way. Now, if you want to impair the operation of justice in greater Minnesota, go right ahead. I'm not getting on that bandwagon. People in your communities, your crime victims, deserve to see justice just as much as people in the metro area.
Senator Westrom.
Thank you, Madam Chair. Senator Latz, I think in a nutshell, what your bill seems to be doing is creating sanctuary courthouses, much like we've heard sanctuary cities and some counties. And so how is it different from sanctuary policies that haven't served the state generally well? Because if the illegal immigrants weren't here in the first place creating that crime or doing that crime, they wouldn't even be going to court for a hearing. So how does this not just create a sanctuary courthouse in addition to sanctuary cities and counties that have chosen to do that?
Senator Latz.
Madam Chair, Senator Westrom, first let me clarify a couple of things. Court proceeding is defined in the bill as civil proceedings, criminal proceedings, and administrative proceedings before the Court of Administrative Hearings, the Workers' Compensation Court of Appeals, or the tax court. So there will be plenty of people that would be covered by this bill that will be attending court or engaging in court proceedings that are not alleged to have committed any crimes whatsoever under state law. Number one. Number two, if ever there was an essential place where there ought to be, as you describe it, sanctuary, because I know that you guys like to use that term, just like you like to use the term fraud as often as you possibly can. If ever there was a place where there ought to be that protection, it's in our courthouses and the places where people access justice. As far as I'm concerned, justice should apply to all participants, no matter their legal status. You also like to use the terms illegal immigrants. We've already heard from our testifier at the very beginning of this proceeding, there are a lot of people here in this country who may be in violation of civil immigration law that aren't illegal in that sense, in terms of breaking criminal laws. So however you want to characterize the individuals that would be subject to lawful immigration enforcement, my point is, if they are involved in a judicial process in our justice system, that needs to be protected, or we have no longer become a state of laws.
Senator Westrom.
So Madam Chair, Senator Latz, would it make sense in your legislation to exclude the criminal procedures that are going on from this protection, or distinguish a difference? Because somebody that's here illegally, burglarized, assaulted, child molested, the list can go on. I think we want them people out of our neighborhoods generally, and to have justice served in the sense of not having to worry about them harming our children or our neighbors or our mother or our fathers or relatives, generally speaking. So I guess it's puzzling that we would want to give this kind of a protection to somebody that's accused of murder or burglarizing folks or other heinous crimes. And your bill is pretty broad, and it seems to give every one of them that type of protection. If that's where the immigration enforcement is finally successful in catching up with them, I think most neighborhoods would like to make sure that that person is now in custody and not going to be terrorizing, committing those kinds of crimes that they're facing. But just a thought, I guess. More, it's a pretty broad bill as you just described it. Those would be some of my initial concerns as well. Thanks.
Senator Latz.
Madam Chair, Senator Westrom, you shifted language there right in the middle of your commentary, because your first language said people who did murders or burglaries and so on, and then, or committed those offenses. And then you went on to say people accused of offenses. But the underlying premise, and you understand this as an officer of the court, as a lawyer licensed to practice law in Minnesota, as we all should understand, that no one is guilty until they're proven guilty or plead guilty and convicted. Once they're convicted, I think we have a different analysis going on here. But until that happens, if it happens, we have due process. We have a Constitution that guarantees rights, including that due process, which involves participation in the judicial proceedings. A defendant, a person accused of a crime, has a right, once they are given terms of release by a judge, whether it's bail or a conditional release with an ankle monitor, or whether it's a promise to show up next time because they're minimal flight risk or risk of reoffending. Those are the two key questions when conditions of release are set. What's the likelihood of them returning to court? And secondarily, what's the likelihood of them being a safety threat if they're released back into the community? They have a right to go back into the community, continue to work, continue to provide for their family, continue to do whatever they do as a freedom-loving, liberty person, unless and come back to court as many times as are necessary under the due process of law to determine the outcome of their case. They could demand a speedy trial, or the proceedings might take a while. But they aren't done until they have been convicted. And often, as you know, Senator Westrom, a charge, a complaint that has 2 or 3 or 4 or 5 counts doesn't always mean they're going to be convicted of all of those counts. And sometimes, I've seen it, those of us who practice law in the criminal courts have seen it, the top count or the second count, the prosecutors are never going to be able to prove it beyond a reasonable doubt. So I'm not going to sit here and assume that they are a criminal offender or a criminal offender of an offense that they have been accused of committing, unless and until there's a conviction. This bill is all about the process up until the point of conviction, or sometimes even until they're sentenced.
Senator Westrom?
Madam Chair and Senator Latz, I hear a parsing of scenarios in your response as well, but you are talking about a court proceeding. Some of them are criminal activities that somebody here illegally has done, but it forgets the premise that they are criminal for breaking into the country in the first place, and this would limit immigration enforcement officers from catching that burglar at the courthouse, or the murderer, or the whatever crime, small or big, because you'd say, no, you got to go find them in the neighborhoods instead of at the courthouse, even though they committed another subsequent crime after they came into the country illegally in the first place, which is also a crime, as we heard from the testifier that opened up our committee today. And so I note that you kind of forget that premise as well, but we could go back and forth. I understand what you're saying on the criminal side of things, but if it was, if they weren't here illegally in the first place, you wouldn't have that situation, and then they wouldn't be being detained at the courthouse, and we'd have no need for your bill in the first place because they're here legally.
Madam Chairman, maybe I should get some clarification from counsel on this, but my understanding is that if there is a judicially issued warrant, even on an immigration matter, that this would not preclude their arrest from a courthouse, but I should clarify that.
Ms. Primo?
Madam Chair and members, yes, the definition of civil arrest includes those exceptions. At line 1.16, civil arrest does not include an arrest that's supported by a judicial warrant, and that would include an arrest related to civil immigration enforcement.
So, Madam Chair, Senator Westrom, the scenario that you just posited, if they've got a judicial warrant for their immigration violation, then law enforcement could go into the courthouse and arrest them.
Senator Westland?
Thank you, Madam Chair. Senator Latz, so my understanding of your bill is this creates basically a 1,000-foot area in which this is not, the civil arrest cannot take place in order to preserve, judicial, the ability for a judicial system to function. The minute that person steps outside the 1,000-foot area, they could be detained. Is that right?
Senator Latz?
Madam Chair, Senator Westland, yes.
So even if they're at the Circle K, I don't know if that's a thing anymore, Circle K, within that 1,000 feet, I assume they're not going to stay there for days on end. I assume they're going to leave there and potentially go home. And the minute they leave that 1,000-foot perimeter, they're subject to being detained by ICE. Is that right?
Senator Latz.
Madam Chair, Senator Westland, that's my understanding. I'll look to counsel to see if I understand that incorrectly.
Ms. Primo.
Madam Chair, members, I'm sorry, could you repeat the question?
Senator Westland.
So in essence, if somebody has been at a judicial proceeding, regardless of their role, the minute they leave that 1,000-foot perimeter, then they could be detained by ICE for a civil arrest. Is that right?
Ms. Primo.
Madam Chair and members, I'm not sure if that is entirely clear. I am looking at line 2.27, which states including, and then lists 5 separate prohibitions. It's possible that that could be read as either not an exhaustive list or an exhaustive list. That's one issue. The other piece is that clause okay, I'll take that last piece. Yeah, so the main issue is that whether including would be considered exhaustive or not exhaustive. I think if the intention of the author is to limit it in the way that you've described, I'd probably change including to as follows or something along those lines so that these are the specific examples that relate to the prohibition and nothing else.
So just to clarify.
Senator Westland.
Yep, I'm sorry. So just to clarify, so this says the civil arrest is prohibited at a location of the court proceedings, within the courthouse building, on the premises of the courthouse, including parking, on a sidewalk, parkway, or street surrounding the courthouse, and on any public way within 1,000 feet, including sidewalk, parkway, et cetera. So if someone is not in any of those places, I am assuming that to mean that that person is then subject to the civil arrest, that it's just simply in those areas and under those circumstances, they could not be subject to a civil arrest. That's my understanding of the reading. Is that?
Ms. Primo.
Madam Chair and members, I think that a plausible way to read this is that the first part of subdivision 1, which states a person attending a court proceeding is privileged from civil arrest while going to, remaining at, or returning from a court proceeding. That could be read as the general prohibition. And so that could be where someone could say, okay, this is quite expansive. It's beyond those listed clauses. So if the intent is to be more clear, then I would just make sure that these examples, these 5 clauses are it, and that there's no way to read that first piece as like the general prohibition.
So Madam Chair.
Senator Westland, and then I'll go to
Latz.
Senator Latz, yeah.
I think that's your intent, is that correct? That your intent was to say that if a person is found in these places, that they should not be subject to civil arrest. Is that accurate?
Senator Latz.
Madam Chair, Senator Westland, yes, my intent was to create a bubble of protective space so they can effectively participate in the justice system. Once they're outside of the bubble, then ordinary law would apply to them.
Okay. And then just lastly, because this point has been raised before, but I want to bring us back to this. If a person in this country is potentially subject to a detainer or to a civil arrest, and they are also a criminal defendant in a proceeding in our state court for a crime that's been committed, if they are removed from the country before that criminal process has completed, that means the victim of that crime will never see justice for what they have experienced. And if someone is convicted of a crime here in our state, they should serve their time here. And then if they are subject at that point to deportation, then they should be deported. But my understanding, perhaps you can clarify this for me, Senator Latz, maybe I've got this wrong. My understanding is if you pick up a criminal defendant who is subject to a charge for a crime in our state, and they are deported from this country, they're just removed from the country. They're never, ever subject to a criminal proceeding for violating a law in Minnesota. Isn't that correct?
Senator Latz.
Madam Chair, Senator Westland, theoretically, the case could remain open indefinitely.
But they'd have to be here.
But it can't proceed without them being here in person to proceed.
So,
Senator Westland.
Madam Chair and Senator Latz, I guess the point I'm making is if they get deported, the case here could remain open, but if they aren't here, they can't be convicted, they can't serve their time, they can't be punished for their crime. They're just going to be deported somewhere else, and the victim here never receives justice. Is that my understanding correct?
Senator Latz.
Madam Chair, Senator Westland, yes.
Okay, I'm done.
Senator Clark.
Thank you, Madam Chair, and Senator Latz. I guess I'm more focused on witnesses to a crime, say a crime against me. Does this, if someone has, vulnerable status as is here in the United States, in Minnesota, and they have witnessed a crime against me, say by Senator Westland, are they, sorry.
I'm known to.
Say by my friend Tim, are they protected under this as a witness to the crime that Tim did against me?
Senator Latz.
Madam Chair, Senator Clark, yes.
Okay. Thank you.
Senator Clark.
I guess that's, thank you, Chair. Thank you, Senator Latz. I think that's part of it for me is that, it includes witnesses. And this is we want to let justice, do its work. And if the witness is no longer available, I'm sitting here and I still got Tim I got to look at who punched me in the face. Thank you.
Okay, final comments from you, Senator Latz.
Nothing further, Madam
Okay.
Chair.
I'll invite you back up to give any final announcements for the committee, but with that, we'll lay over Senate File 3699.
All right, members, final announcements. Members should expect committee hearings each Friday in March to meet our legislative deadlines. It's a short session, and we still have a lot of work that will be coming through here. We try not to let this committee become the bottleneck that stops legislation in its tracks just because we don't have the capacity to move it along. So we do typically see about 50% of the bills that are introduced in the legislature that are moving through the process, either through original jurisdiction or re-referrals, because it's got one portion of a bill that's within our jurisdiction. So we will do what we have to do not to be bottlenecks. So you should plan on Friday hearings in March anyway, and the last deadline is the end of March, and after that we're pretty much done as a committee. Our next hearing is going to be Monday, February 23rd. That's this coming Monday, 12:30 p.m., our usual committee time. It'll be in our usual committee hearing room as well, G15. You should note there are new security protocols for entering and exiting that hearing room as well. Except for Senator Holmstrom, they'll just be the committee or security protocols that you'll become accustomed to. Again, welcome to Senator Holmstrom to the committee here. And appreciate everyone's time working through lunch hour. I, for one, am very hungry now, so I'm ready to go get a bite to eat. Unless there's anything further to share, we are adjourned.